Section 10 of the Highways Act, illegal construction, 2022.
Give the number.
Item number 605, my lord, senior citizen aged about 80 years. In front of the petitioner's land, my lord, national highways land has been encroached by the local hooligans or political leaders, my lord, and continuing their illegal business, my lord. And so, my lord, I am paying for the upgrade.
It's in the monthly list.
Yes, my lord.
My lord, may I permitted to mention?
Senior बोलें
second matter despite making entire money, but third party interest is going to
Group 1 matter.
Group 1 matter. 845 and 970.
Give the numbers.
Lordship, one upgradation, my lord. Only,
For what? What is your urgency?
my lord, there is a direction of your lordship matter to appear 18th of May, my lord. What happened, my lord? ADDA is transferring my own land to another party. My lord, there is a direction of your lordship to file a report to the ADDA. They have not filed.
Give the number.
May I have lordship's kind leave to mention a matter, my lord? My lord, the urgency is this, my lord, all senior citizens, 40 years, my lord, their land has been taken, no money given. First round litigation owned. State of West Bengal now thinks, my lord, I am supposed to get 7.5 crore as per state of West Bengal. Now, my lord, all our senior citizens, they are not getting the, my lord, the compensation, admitted compensation. My lordship was earlier occasion, please to fix the matter, but some kind of business of this code matter could not be taken up. So any day convenient to your lordship, my lord, any day. I am not saying that.
My lord, may I permitted to mention, my lord, matter, my lord. Matter relates to the group 1 matter, my lord. My lord, urgency is that, my lord, third party interest will create, my lord. The respondent authority is going to auction the Moja, my lord.
Give the number.
My lord,
Please, my lord. Well, item number 509 of your lordship's combined monthly list, my lord. This matter, my lord, relates to the Salt Lake property. Lordship will kindly recall, my lord. But this was argued before your lordship by Mr. Aniruddha Chatterjee that, my lord, as my lord, the original co-leases are going to transfer, my lord, they cannot
Transfer fees matter.
Yes, transfer fees, my lord. The state has come, my lord, they could not show anything, my lord. Last occasion also they appeared.
Give the number.
And they are all, but this is the fight.
my lord, item number 930. My lord.
Actually, there is false identification of the two land, but it has already been entered in the court and the lordship was order and the last order, the lordship was pleased to fix the matter on 18th May 2023. Kindly for updation for that. There is false identification.
Give the number.
My lord,
One matter, may I?
item 930. I would like to please you that if you could list the matter for withdrawal.
For withdrawal.
Right.
To be mentioned withdrawal.
My lord, item number 1121, my lord. Upon mentioning on last 2 months, this matter was listed on daily list from the combined list, monthly list. But unfortunately, the matter was not called on. Matter is for illegal construction, my lord.
Give the number.
Thank you.
Contempt application.
My lord.
Affidavits are complete.
Dated 31st January 2023. Affidavit operation file within 3 weeks and reply within 15 days. No affidavit operation file by the respondent. And I'm not senior citizen.
Give the number. Let me see.
My lord.
I have
My
the
lord, may I permitted to mention. My lord.
Hearing matter. Hearing matter.
My lord, may I permitted to mention, my lord, 5 matters. They relates to group 1 matter. My lord, long-term mining lease. The auction is going to be very short. My lord, if the auction starts, then the third party right will be created, and the petitioner will lose. My lord, kindly
Similar matters. All 5 matters are similar.
similar matter. My lord.
May I have your lordship's kind leave to mention item number 204 of monthly list, my lord. The urgency is, my lord, without any acquisition proceeding, the PHE department started a water project over my property. Initially, the property was vested. Subsequently, pursuant to the order of this High Court, that was released. Now, in spite of that, they are, my lord, acquiring the property, take possession of the property, and started a water project over my property.
They have acquired the property.
No acquisition. Initially, it was vested. Thereafter, that was released pursuant to this order. But in spite of that, they have not handed over the possession. They have started a water project over my property, my lord.
The number, please.
My lord, 916, my lord.
Item number 437 of the monthly matter was appearing in the supplementary list somewhere around 70 to 70.
It's at the motion stage.
Yes, my lord. But I'm seeking for upgradation, my lord. She is, my lord, petitioner at the 70 years old lady. My lord, she, my lord, was successful in a process of lottery held by KMDA for allotment of a plot of land. Not for more than a decade, my lord, the KMDA is sitting over my money. All the documents have been executed. Position has not only been, my lord, handed over.
Give the
Second
number,
round of
give the number, give the number.
My lord, 916, my lord, combinedly, the private respondents made unauthorized construction in front of my right land, my lord.
Give the number. I think that's all for today.
One matter,
New motion, your lordship,
This is a never ending mentioning, sir. Come back tomorrow. Tomorrow,
My lord, illegal construction.
tomorrow.
My lord, illegal
Case
construction.
list.
Five, lordship, one matter, lordship, yesterday, Mr. Parthapratim Rai mentioned it before your lordship. It's a determination of lordship, Justice Vivek Chaudhary.
Yes, yes.
Lordship, while lordship, the fair point shop, lordship, vacancy will be filled up, lordship, by rejecting the application of the petitioner on a false ground that my godown is situated over lordship with PWD land. PWD land is lordship opposite to the,
Mrs. Chaudhary will join on Monday. So
now
can't
lordship,
you
they
can't
are
wait
going
till
to
Monday?
declare the vacancy, lordship. If the vacancy declared, lordship, I am lordship out of lordship. There will
If
no.
the vacancy is declared, nothing happens. After that, they'll take necessary
Lordship,
steps.
they will be lordship start the lordship shop lordship immediately after declaration of the vacancy lordship, because after inquiry has already been completed long back. Now lordship, the result of the inquiry lordship just now lordship we have been informed. That's why
Will you
lordship
put
they
the
are,
other side on notice?
yes lordship, the state lordship we have informed lordship. Kindly
Show me the notice, please.
notice lordship, I have noticed. Kindly
Different determination, put the other side on notice.
now lordship, the problem is lordship, Justice Chaudhary lordship sit on the next week lordship.
Yes, put
By-
the other side on notice at least.
Now, lordship, actually, stay is required, lordship. We will put notice, lordship, by in course of the day, lordship. If lordship,
I
we
will
did
not
not,
take up pensioning without
lordship,
notice.
if we did not serve notice upon the state respondent, lordship, kindly matter, lordship, go out of the list, lordship.
Mention upon notice. Yesterday I told you the same thing, isn't it? You should have put that side on notice.
My lord, item number.
Tomorrow again, sir, I have said mentioning sufficiently has been taken up today. Please come back tomorrow.
My lord, I am mentioning the,
Sir, I have just
the
said,
petitioner is 82 years, sir.
you have heard what I have said, sir. Please,
I am waiting.
case list.
My lord, I am waiting.
Yes.
one.
I
Can't help, sir. I cannot take hundreds of mentioning. Or if you permit me, I'll include the entire monthly list into the supplementary list. If that helps you,
tomorrow, I shall come tomorrow.
please try your luck tomorrow. Hundreds of mentioning each day cannot be taken up like this. Yes, days list.
Item number one. I am for the petitioner.
Yes,
This is for extension of interim order. It relates to my lord renewal of.
respondents.
My lord, I
Your
prefer.
opinion?
My lord, kindly extend it for a limited time, my lord.
And extend limited, but kindly fix my lord for hearing at an early date. Well, both parties are suffering. We are not carrying on the business. They are not getting the revenue.
When did the the order expire?
Yes, yes. It is still April.
এখন আছে তো order, interim order আছে তো?
It was extended till the end of March 2020. After that?
No, no. The last occasion it was extended, my lord, till the end of April 2020.
Oh, 30th April 2020. We are in June.
First of all.
So nothing has happened without the extension.
That's-
So let it be, let there be a hearing.
My lord,
I'll fix a date for
it is
hearing.
it is already in the hearing list, but kindly extend the interim order. On the
Where
last
is,
occasion,
where
my
is
lord,
the interim order to be extended? That is my question.
my lord, kindly see the order.
The interim order should be there for extension.
Yes, my lord, kindly take the order.
It was till 30th April.
10th of February, December 2018, Justice Bosak, my lord, passed the order. to the
Maybe.
effect.
I'm not worried about the order at all. It was extended lastly till 30th of April 2023.
Yes.
So today there is no interim order at all.
That's true.
So what shall I extend?
Application করুন একটা।
There should be an order to be extended.
That's true. My lord, it may be reimposed and my lord extended.
It has to be heard out in that
That
case.
on an application. my lord.
My lord, it may be
Of course.
reimposed and my lord,
Application
if your lordship so discernment, I have to file. it.
since April, you are not facing any difficulty without the order also. isn't
But
it?
it's true that I am not.
So let me fix a
But it
date for
may-
hearing.
Well, it may happen. It may anytime.
Come
That
back-
meant I shall be in difficulty.
Come back to court in that case, if it happens, because you're,
Well, kindly make it not today and not tomorrow. In the meantime, by tomorrow I shall file the application. Kindly make it not today, not tomorrow.
you are not interested in the hearing.
I am if your lordships, even today my lord can take up, I'm ready.
And let me fix a date for hearing. There was no date.
In
for
that
hearing
event, my
fixed.
lord, if your lordship kindly fix a date, my lord, if tomorrow, day after tomorrow, if your lordship take up the hearing, I have no difficulty. But otherwise, my lord, if it is fixed after 10 days or 20 days, in that event, my lord, kindly extend the interim order.
Come back on 28th June for hearing.
Well, now, today is my lord only 6th, 28th, my lord.
Yes,
means
sir, you have been waiting since
another month. It is
30th
another-
April.
Well,
You have
I-
been waiting since 30th April, so I don't
I
think
am
you can
humbly-
make such
what I am
submission.
humbly praying.
Come back on 28th June for the hearing.
But what I am praying humbly, kindly make it adjourned for 2 days. Tomorrow I shall file the application. It will be listed on for
This
hearing
was
on-
only fixed for extension of interim order. How can I adjourn the matter for you to come back with an application? There is no application on record.
On the last occasion also, my lord, the interim order extended after expiry. On the last occasion, when my lord extended the interim order, it was also.
That goes against the petitioner, my lord. We should have pointed out to the court. It's our mistake, my lord.
If a mistake has been committed, it cannot be repeated, isn't it?
That's true. My lord, therefore, I am
Come back
humbly
on
praying.
28th June, this month itself for the hearing.
All right, my lord, fix it 28th, but day after I shall file the application.
If you
and
have any
mention what
difficulty in
is
the meantime, you can approach the
my-
court.
my-
There shouldn't be any difficulty. Because since April, nothing has happened. We are in
That
June.
does not mean, my lord, it will not happen on the, during this 28th of June. Contested hearing, my lord.
Affidavits have been
the interim order-
exchanged. Let the matter appear under the heading Group 1 hearing on 28th June, 28 June 2023.
Grateful, my lord.
একটা line add করুন ওটার আগে। The interim order granted earlier has expired on 30th April 2023. তারপরে the evidence have been exchanged. Next,
Similar situation is in this matter also.
your
More so,
appeal is done.
since last 3 years, the interim order is being extended from time to
And
time.
our
And the
argument
matter
has been
is,
complete. Our argument has been complete.
That-
They have stated the argument.
that,
Therefore, my
that
lord,
was before,
completed our.
before another bench,
Not
not
before this.
not
Yes,
before.
before this bench.
No, no.
Justice Mr. Satyangshu Basu argued before your
Argu-
lordship.
Yes, just opened.
Not opened. Our argument has been completed.
If it is completed, then you will reply.
Mr.
I shall-
Basu started.
Kindly fix the date.
my lord.
The interim order has been, my lord, has expired on 30th April.
So let there be an understanding that nothing shall happen in the meantime.
There cannot be, my lord, the maintainability of the writ petition is kept open. In spite of that, my lord,
Mr. Taluk, you have waited till this date. So
kindly-
please wait till the matter is
when-
taken up.
my lord, when 30th April, the interim order expired and nothing has happened, my lord, it need not be recorded in the order. Lordship,
No,
kindly
it will
fix
not
it.
be recorded. I'll fix a date for hearing, but please
Fix a date.
instruct your clients that
That,
nothing should
that my
happen. in the
learned friend
meantime.
knows also me.
No, my lord, on the last occasion, several occasions, my lord, the interim order is- whatever, my lord, I shall file the application.
Since last 3 years.
Nothing to say. It is my fault that
Same order.
application has not been filed. Therefore, I am to
Same
file.
order. 30th April 2023.
This morning.
Oh, a date for hearing a date.
Let it be on 28th.
Same day, two hearing matters?
I have no difficulty.
If, then let it be on.
Let it appear, let us see. Same date, 28th.
I shall pay, my lord, if it is taken up earlier too.
Okay.
Because since the interim order is not there, I am praying for your lordship, it may be taken up.
Same month I'm giving up.
I'm good.
Matter number 3. I am appealing for the petitioner, my lord. Relief in this writ petition has already been, my lord, granted, my lord.
Yes, the relief is
Relief-
granted.
Yes, has already been granted, so I am praying for ultra.
It is submitted on behalf of the petitioner that the grievance of the petitioner has been redressed Paragraph in view of the above. Nothing further remains to be adjudicated in the writ petition and the same is accordingly disposed of. As in certified website copy.
Item number 4.
I am opposing this extension of interim order. Madam.
Order keep today, that matter is appearing for again.
It's
Well,
appearing for hearing?
Yes.
Malad, this, Malad,
Till hearing of the list, interim order will come.
Malad, this is a matter where contract for ferry service has been granted without floating any tender. The same writ petitioner had previously challenged an order of the cantonment board for calling for tender and the appeal court has directed. Malad, I filed an opposition. I have given the specifics. Division bench has held Malad without floating a tender contract. No, it can be heard. Malad, this is. Well, then let it be heard expeditiously because my lord, our it was heard by then another.
It has not been fixed. Let me fix a date for hearing.
My lord, kindly speak a
And let
specific
them-
date and hear it out because it will not take much time. There is a
Yes,
division
and,
bench
Let the
judgment.
Interim order be extended for a limited period.
Let it be limited, my lord, but kindly fix an early date,
I'll
my
fix The matter is ready for hearing. Let the matter appear under the heading hearing on 5th July.
My lord.
Paragraph, the interim order granted earlier is extended till 31st July or until further orders, comma, whichever is earlier.
Number 5.
My lord, I am for the petitioner, my lord. My client doesn't want to proceed with the matter, my
My
lord.
lord, may I?
The
My lord, may I?
petition along with contempt matter, my lord.
This is a contempt matter, my lord.
Yes.
But
My
both,
lord, non-prosecution will endure to my benefit. But my lord, I must point out to the court, my lord, certain facts. I must, my lord. May I, my lord? Look, this application, the writ petition was filed alleging that a water body has been filled up and illegal construction is made thereon. Lordship has been very pleased to pass an order of status quo. Lord, contempt filed alleging that in spite of order of status quo, the constructions are being carried on. Lord, photographs have been alleged in the contempt application. It was my lord's pleasure to call for a report from the alleged contemner. Lord, we are ready with the report. My lord, subject to what falls from the honorable court, my lord, the carriage of prosecution in a contempt application does not rest on the my lord petitioner. I have to pass the hard test of proving myself that I have not committed any contempt. My lord may kindly fix up any date. My lord will kindly appreciate the reports and my lord will pass
You
necessary
ready
orders.
with your reports?
Well, I am ready with the report today, my lord. But if your lordship so pleases, your lordship can pass, my lord. My lord will kindly see the contempt application. The prayers are, my lord, narrated in the contempt application at page 11, my lord. Prayers C, my lord. Lordship has come to page 11 of the contempt application,
Give me a minute, please.
my lord.
The writ petition is still pending.
Still pending, my lord. The
Yes, ma'am.
order of status quo, what I'm apprehensive, my lord, as an officer of the court, my lord, I must put before the court, my lord, for my lord's consideration, my lord. Today, the status quo order is staring at my face. The contempt application will, if it goes, my lord's order may not lose its force, my lord. That's my humble understanding, my lord. Even I have pondered about whether to.
I
Want to proceed with the writ petition itself.
writ petition and also, my lord, contempt application, my lord.
Writ petition can be disposed of. on
Definitely,
the-
definitely.
But the contempt application, it has to be dropped.
I am well conscious, my lord, how strict your lordship, this bench is, my lord, in contempt application. But, my lord, it's my duty to pass that test.
Ma'am, in this matter, my lord, Mr. Devjit Mukherjee is appearing. 5 minutes pass over, my lord, he will come, my lord. 5 minutes pass over, my lord, he will come.
Are you ready with your report today or shall I give you an adjournment?
My lord, I can come on any date or your lordship can take up the report. My lord.
Have you given them a copy?
My lord, we have given the copy, but her senior is not there, my lord.
Will you come back some other day in that case?
No, my lord, 5 minutes pass over, my lord.
Passover is not possible in this court.
But tomorrow, my lord, tomorrow.
Five of the matters can be taken up.
My
My
lord.
lord, I am not opposing, my lord, but my lord, it's my duty to point out to the court, my
No,
lord.
tomorrow, my lord, tomorrow, my lord.
Contempt has to be dropped
Absolutely.
and
my lord.
the writ petition disposed of.
Look,
But kindly take it up tomorrow, my lord.
Contempt draft if there is no act of contempt.
Absolutely.
No, আমি tomorrow করবো, আজকে করবো।
So will you, you want to
Ma'am,
submit the report today or shall I make
let
it?
the report be kept on record, my lord. May I come back any day?
Give
my lord?
her a copy.
My lord, I have given her a copy.
In that case, please come back next Monday.
My lord, may we come back on Wednesday?
Tomorrow, my lord.
May we
Yes.
come back next Wednesday, my lord?
Uh,
Monday, any day
that's
except
Wednesday week.
my lord,
That is 12th.
my lord,
No, I'm sorry. 14th,
my lord.
14th June.
Yes, my lord.
On prayer of the petitioner, the matter is urgent. তার আগে করুন, report in the form of affidavit submitted on behalf of the alleged contemner is taken on record. Paragraph on prayer of the petitioner, the matter is urgent. Let the matter appear under the same heading on 14th.
I'm grateful, my lord.
Number 6.
Hello, brother, return.
My lord, in this matter,
I am appearing for the petitioner.
I play some time, my lord, because my lord, before vacation, my lord, I told them to come with the complaint, but after that, my lord,
Oh, this is contempt.
yes, my lord, I play some time.
A learned counsel for the alleged contemner seeks further accommodation to comply with the order under contempt. Paragraph, let the matter appear under the same heading on 26 June, sufficient?
Number 7.
Item number 7 or 8 may be taken up analogously. And if your lordship kindly takes item number 8 for your lordship's kind
Who
consideration.
is appearing for the respondents? You're
And
appearing?
Mr.
7 I am
Bandyopadhyay,
appearing.
Oh. 7, 8 দুটো
and on the last occasion, your lordship may recollect under the learned counsel for the respondent authorities took the point of maintainability, indicating to your lordship that this order is an appealable order in terms of Rule 51 of the West Bengal Mineral Concession Rules. And I pointed out to your lordship that this order is not appealable in terms of Rule 51 because the order has not been passed. Whatever order has been passed is not an order contemplated within the rules itself. It's a question of renewal. But your lordship will kindly appreciate take our supplementary
Shantanu.
affidavit which we have used in WPA number 20427 of 2022 for your lordship's kind consideration.
That's item number 7.
No, 8, I believe. 2047,
Eight.
item number 7. I'm so sorry, Mala, item number 7.
You're referring to item number 8?
Mala, it's all the same, Mala.
So I'll take up 7?
7, yes. Mala, kindly take the supplementary affidavit.
Yes.
Mala, I indicated to your lordship that now, in view of the new policy of the government, lease or concessions can be granted in respect of these kind of minor minerals could only be in favor of the riots. And it is an established fact, a fact which is beyond any dispute that I am the riot, recorded riot of the subject land. So, my lord, there is no other option but to grant these in my favor. And there is no scope for any auction with these kind of minor minerals as indicated in the new policy. New policy টা কোথায় আছে? এই, এটা কোন supplement-এ আমায় কি বুঝতে পারি না। Yes, my lord, kindly take page 12 of the supplementary affidavit for your lordship's kind consideration.
Page 12.
12, 1, 2.
Yes,
May I just take your lordship through the supplementary affidavit to this new policy?
yes.
This is the
page 12.
notification dated September 22, 2022. My lord, may I just read out the preamble? Whereas the western districts of the state, such as Birbhum, Paschim Bardhaman, Bankura, and Purulia, have huge reserves of minor minerals like blackstone, china clay, and fire clay, quartz, and feldspar, etc. Majority occurrence of which is found in private or rayati land. And whereas the state government was considering that a huge population of women and men workers were associated with and earn their living from multiple ancillary industries associated with mining, such as in crushing, processing, and transportation sectors, will benefit from a mining policy in rayati land. And whereas to encourage extraction of these minerals in a sustainable manner, following all statutory environmental guidelines, the state government, with a notification dated September 24, 2021, declared that it will bring out detailed modalities of mining of minor minerals in rayati land. Now, therefore, the governor is hereby pleased to publish the policy of mining of minor minerals in private or rayati land for the state of West Bengal. Now, my lord, kindly take the policy clause 1 of the notification. Only the rayat owning the land can apply for a mining lease. They may apply individually or organize themselves in a group of rayats or company. All the legal documents shall only be issued in the same rayat group of rayats company, thus ensuring complete ownership, responsibility, and equitable social justice. The application shall then be evaluated by the district land department regarding authenticity of ownership of land and forwarded with their recommendation to the state nodal agency, that is West Bengal Mineral Development and Trading Corporation. Now, my lord, WBMDTCL may grant provisional letter of intent if it is prima facie satisfied. LOI shall be issued against the payment of an advance fee. Based on provisional LOI, the rayats will get mining plan prepared by the qualified agency, establish the mineable reserve, and get it approved by the competent authority. Thereafter, he or they shall submit application for environmental clearance to State Environment Impact Assessment Authority. The rayat shall be responsible for prospecting, etc. Now, we will kindly take clause 5. The lease shall be granted for a period of 5 years or till the reserve is exhausted, whichever is earlier, with a provision of extension for up to 5 years at a time, depending upon the mineral reserve established, adhering to the statutory norms and discretions of the state government. For any extension of mining lease, the mining lease fee shall be calculated based on the revised approved mining plan or environmental clearance at the time, has to be paid again. The lessee shall pay royalty, cess, DMF, and other statutory payments as applicable, and obtain excavation permit during the entire life cycle of the mines. The willing lessees and contiguous plots are allowed to execute agreement between or among them for common area extraction to promote scientific and sustainable mining. Then the standard operating procedure is laid down. But in this case, the lease was already granted. The operation was suspended, transit passes were not allowed on the ground that a criminal case has been registered against the lessee in question. That criminal case has not yet resulted in any conviction as such. In fact, the criminal proceedings are now under challenge in a criminal revision. And I have annexed the orders passed by this honorable court dealing with the criminal revision matter. Having regard to the totality of the circumstances, today, I have all the clearances. Admittedly, I could not work my mind because the transit passes were not issued on the ground of pendency of a criminal case. So I am seeking the benefit of this policy, that this policy may be extended to me because there is no other option, because I am the rayat. That is my case before your lordship.
You have assailed certain orders. What are
I
they?
have assailed certain order, but my lord, I must be candid before your lordship. The primary ground of challenge was violation of section 8 capital A of the MMDR Act. To be candid before Lordship, my lord, that ought not to have been the challenge because sections 5 to 13 of the MMDR Act do not apply to minor minerals. But that's a position of law which nobody can dispute. I cannot dispute. That's a position of the statutory provisions as it stands now. My lord, so my lord, my prayer now is restricted to extension and also, my lord, for the period for which I could not work the mine. Having regard to the new policy formulated on and notified in the official gazette on November 23, 2022. That is my substantive case before Lordship. But I have to be candid before Lordship. That was not the subject matter which was considered by the district authority. But as an officer of the court, I must say so.
So you have to mold your prayers actually, because you have asked for setting aside of those orders, isn't
And
it?
I have
That's all.
asked for man also for renewal. So I am on renewal also. Well, kindly take my prayers, which I made in the writ petition, subject to correction. Prayer B. Well, I need not mold my prayer having regard to the prayer B. Prayer B, A, my lord, that order basically has outlived its utility, to be very candid with your lordship. Prayer B, if you're
Prayer E.
Mother,
Prayer E is an interim.
prayer B. Prayer B, I'm so sorry, my lord. But in fact, my lord, the criminal case was registered long after the filing of the writ petition, the first writ petition. Actually, a contempt petition was filed. So, my lord, your lordship knows it is when we get the department, we invite also the wrath of the department. So it is an exposition of the wrath of the department.
Let us hear the state.
This writ petitioner, they have prayed for setting aside of an order passed by the district authority.
They are not pressing this prayer.
Yes, my lord. But
They
now,
are only pressing prayer B.
yes, my lord, but this point, this my lord, notification which they are relying now, my lord, that has not been placed before the, my lord, the district authority at the time
They are
of
not
hearing.
pressing this at all. So forget
Let them
about that
approach
prayer
before the
A.
authority, as per my lord, this rule, authority will consider whether that can be extended or not.
My lord, what is the option? My lord, is it the case of
Authority has
the?
not at all considered this, my lord, point, my lord.
My lord, may I
But they are, my lord,
They-
now,
I'm
I
sorry,
think your lords.
I'm sorry.
Let them approach for the authority as per this, my lord, notification, my lord. Which they are now, my lord, they have annexed.
But this is the policy of the state. I think, my lord, it is not gainsaid by.
So why don't you, Mr. Mujumdar, file an application before the authority? I'll give a direction upon the authority to deal with your application in the light of the notification,
New policy.
new policy.
Well, that's an option. That's definitely an option. Well, I cannot,
Because he is
I
correct in
cannot
a
be,
way. Because
but
the
my lord, may I
authority-
just humbly submit with your lordship? My lord, I make an application. My lord, in fact, my lord, for extension, my lord, kindly visualize one thing. My lord, till date, my lord, by the transit passes for the prior lease are yet to be issued. On the ground that there is a criminal case and all that. But the pendency of criminal case can never operate as an impediment. Your lordship has held it so many times having regard to the provisions contained in the lease deed itself. So, my lord, today, my lord, if your lordship makes it clear, subject to your lordship's kind consideration, obviously, that, my lord, that pendency of the criminal case will not operate as an impediment, and they will consider in terms of the policy, I will make an application. Definitely, I will make an application.
That date has already been expired, my lord.
No, my lord. This is
Earlier,
an
my
extension.
lord, please,
No,
that has
my lord.
already
My
been
learned friend is getting me wrong. My lord, this is an extension in terms of that lease. I have moved writ petition prior to the expiry of the lease. It is not gainsaid on behalf of the state respondents. I waited till the expiry of the lease and then I moved the writ petition and then I'm trying to enforce the right.
Has the authority recorded that due to the criminal case, the transit
My lord, the
passes were not
authority has
issued?
now simply gone on section 8A.
I mean, has the criminal case been stated anywhere in the
My lord,
orders?
The criminal case is
But
not the relevant here, my lord.
Hey,
You
Lord,
lordship, in the earlier repetition, you lordship passed an order directing the
my lord,
district.
this order was passed on 18th of February, the 3rd of June 2022. And the criminal case was registered in October.
So how does the criminal case come
My lord,
into the
today, my
picture?
lord, this is my apprehension. kindly make it,
Comprehension cannot be considered.
my lord, kindly make it clear, my lord, this they will consider solely on the basis of the policy and not otherwise. That can be done, my lord.
Because
Because I know what is going to happen. I know there will be another round. I know they are going to reject, and I know I have to come. To your lordship.
They're only apprehending, criminal case.
My lord, the apprehension, my lord, my experience will prove to be correct, and I know there will be a third round. And then I will come to your lordship and point out to your lordship that this is what is happening.
because the criminal case factor is not in the four corners of the.
My lord, kindly take, my lord, their affidavit. Verbally, yes. My lord, only one thing, my lord, then, my lord, the consideration can only be granted, that issue can be, this lease can be decided, the extension can be decided by respondent number 5, the principal.
In the light of the
In the light of
notification,
the
I specifically
Yes,
say
yes,
that.
yes, yes.
That's all right?
Yes. Respondent number 5.
The other matter is also the same,
It's
similar.
it's connected.
Same,
Same.
same.
Both the petitions can be disposed of by a common order.
Criminal case has got no relevance with
Well,
it.
I'm so grateful, Malad, kindly record Mr. Ganguly's submission. Malad, I will be grateful, Malad. If they-
I do not, I really.
Malad,
don't
I
know
tell
how
you,
the
Lordship,
criminal case
Malad,
comes
knowing
into
Mr.
picture.
Ganguly, for years together, Mr. Ganguly will never make a submission contrary to law.
No, certainly not. I try to do it.
Criminal
this is
case
the
is
what-
nowhere.
Very well, Malad, kindly let the
So-
principal secretary decide in terms of the policy.
Yes,
But the
absolutely.
policy decision,
Malad,
but your lordship
Malad,
has already-
Malad, the time for consideration
Yes,
may
1 month,
1 month. Yes.
within 1 month.
No, why 2 months?
But your lordship.
But really, Mr. Bandyopadhyay does not say 2 months and all that.
Extension 1 month.
Extension is 1 month, 1 month. অত চেয়েও না সব। হ্যাঁ।
Mr. Majumdar knows better than me.
আমি
He was
ছ
already.
মাস 6 সপ্তাহ পর content পাইছি।
Then it will be 6 weeks.
6 weeks, 6 weeks. But that is what I told him. After 6 weeks, I will file the contempt. I take your lordships kindly, my lord. So great.
Heard learned counsels for the parties.
Dispose হয়ে গেল। কি হলো অনেকটা?
It is contended on behalf of the petitioner that the
Lord, may I take leave, man?
petitioner was granted, that the petitioner was granted long-term lease in respect of his Rayati land situated at Mouja, Dubeddanga, D-U-B-E-R, Dubeddanga, jail number 5, plot numbers 2691 and 3366, comprising an area of 28.5 acres for mining black stone in the year 2009. Stop. On prayer of the petitioner, the lease was renewed and a new lease was granted in favor of the petitioner on 25th January 2017 with an option for renewal. Stop. Possession of the land was handed over to the petitioner for mining on 14th March 2017. Since the lease has expired, the petitioner seeks a direction upon the authority to renew the lease in his favor in terms of the notification issued by the Government of West Bengal, Department of Industry, Commerce and Enterprise, Mines Branch on November 23, 2022.
November 22. November 22.
It was published on 23rd November.
Yes.
Stop. The petitioner seeks to submit a comprehensive representation before the concerned authority in this regard and prays for a direction upon the authority to consider the representation within a stipulated time frame. Paragraph. It is submitted on behalf of the respondents that the prayer of the petitioner may be considered by the, who should be the authority?
Respondent 5.
Principal Secretary.
Yes.
The fifth respondent in accordance with law. Paragraph. In view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation for renewal of the lease in his favor before the fifth respondent within 7 days. Yes, within 7 days from date. Stop. The fifth respondent is directed to consider and dispose of the representation within 6 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, and in the light of the notification dated November 23, 2022, referred to earlier, in accordance with law.
Transit passes for which I could not take out the materials were already fine. The other repetition,
Where is your prayer?
other repetition.
I'll deal with it there. This one is for renewal, the other is for transit passes. I'll deal with it in a separate order. A paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of? What chapter? Or it take to change. 8. This is for issuance of challans.
Prayer A. Milo, kindly.
Prayer A is again that same, prayer B, I think, is relevant.
Prayer A of the second writ petition. Prayer
Yes,
A of the
second
second
writ
writ petition. My lord, a writ in the nature of members do issue directing the respondents and its main agents and servants to forthwith resign, to withdraw, cancel the order date so and so passed by respondent number so and so, miss case number so and
Where
so.
is this order? 3rd June order?
Page 201.
Yes.
201. My lord. The representation was given for both the prayers regarding issuance of transit pass and issuance of a renewal. No transit was issued. That's why it was issued up till August 2021. I'm entitled to transit passes to September 21 onwards.
May I ask you, my lord, I am for the state authorities. My lord, the led by Mr. Washington Ganguly. My lord, if the lease has expired, my lord, there is no, my lord, possibility for issuing the transit pass.
Transit passes.
My lord,
I am
not only
entitled to-
that, I have an
what
instruction.
I'm harping on is the transit passes prior to expiry of the lease, not post expiry of the lease.
Yes, but how will that help you?
My lord,
Your materials are stacked.
materials were stacked. And taking advantage of those
lord,
stacked
my lord,
materials,
my
they are
instruction
lodging
is
criminal
this.
case against me that I am mining it right now.
My lord, kindly see the paragraph number, my lord, main reason for non-issuing the transit pass. My lord, this is the instruction which has been given by the district authority.
Well, kindly have
My
it.
lord, getting back to without considering.
May I read it for your lordships? The main reason for the non-issuance of challan during the said period was as per the environment clearance certificate issued by the state level environment impact assessment authority. While their memo dated as the lessee is allowed to extract 26,250 Blackstone per year.
Yes.
But as per the office record, it is found that lessee has already extracted beyond the permissible limit for the last mining year of his lease. That is from 25th January 2021 to 24th January 2022. For that reason, the district authority was compelled to stop issuance of the challan in his favor.
My
The
lord,
copy has been also been
Road
annexed.
challenge is not for mining, it is for transportation.
for transportation,
Yes.
not for my.
Well, it takes,
The mining figure given.
well,
He was
extracting,
allowed to extract, he has exceeded that.
yes,
Fine.
yes, yes.
But what about the road challans?
Malad, if they violated the state level environment impact
So
assessment
there's a different
authorities,
provision for it.
yes,
My,
that can be looked
can
into. That can be,
seize- You can confiscate the excess material, you can
Well-
go in. There's a different provision for it altogether.
Well-
You're aware.
and my lord, one thing. I
You
would
cannot
like-
stop issuance of challans
Malad, before the expiry of the lease period.
before expiry of the lease to the permissible limit. You
Yes.
cannot stop issuance, isn't it?
And my lord, the lease period was for a particular period. And my lord, my environmental clear is up till 2028. I have that. The area has got 30 years of reserve.
No. They say per year.
Yes, per year.
26250 per year, you are allowed.
Yes.
You have extracted more than
They have
that.
not assessed that. They're just saying like this.
Malad, as
They've
per
not
the
assessed that.
assessment made by the
Where is the assessment?
Malad, I will take instructions to that effect. Malad, they have given the kindly see, this is not legible copy. That's why I am not showing before your lordship. On the annexures which has
And
been
even
given.
if there has been excess extraction, that you have to follow a separate procedure altogether. You cannot stop transit challans for the particular period to the extent it is permissible, isn't it?
Malad, the authority can look.
26250, he is entitled to
What?
transport. That also you have not issued. So let them file a separate representation on this.
Yes,
Yes?
that
We
can
are
be
filing,
considered.
That was rejected, turned down. That's why a separate writ petition. Your lordship is directing the other writ petition of fresh consideration in the light of the new rule. Your lordship directs the same also in respect of the. And in fact, I have prayed for an interim order of issuance of the ad hoc, at least for 2 months transit. Because they are taking advantage of that stacked material and filing complaint against me that I am mining right now. Precarious condition, my lord, the petition is going.
It is fresh order. The petitioner has assailed the order passed by the District Land and Land Reforms Officer Bankura on 3rd June 2022. Rejecting his request for issuance of transit pass for the period of validity of the lease. Paragraph. It is submitted on behalf of the petitioner
It's very hot.
that
Distracting. Go down.
the authority refused to grant transit pass to the petitioner during the period of lease for which the petitioner was unable to transport the material excavated by him during the said period. Stop. Paragraph. Per contra, comma, learned counsel for the respondents submits that the authority stopped issuing transit pass since the petitioner had already excavated black stone in excess of the permissible limit of 26250 cubic meters, 26250 cubic meters per year.
My lord, one thing
Stop.
I would like to mention that in their order of rejection and turning down my prayer,
This is
there was
last.
no mention.
Paragraph. The order impugned the only reason for rejection of issuance of transit passes stated in the order impugned is that the mining lease was valid only till 24th January 2022, for which the authority was not in a position to issue transit passes subsequent to the said period. Stop. There is no reflection in the said order with regard to alleged excess excavation made by the petitioner in violation of the conditions laid down in the environment clearance certificate by the state level environment impact assessment authority. State level environment impact assessment authority on 4th May 2016. Stop. Paragraph. It appears that the petitioner has sought issuance of transit passes for the period of validity of the lease and not thereafter. Stop. The order impugned is bereft of sufficient reasons as to why the said request of the petitioner was turned down by the authority, comma, more so since there was no request on the part of the petitioner for issuance of transit passes after expiry of the lease period. Stop. Paragraph. In the circumstances, comma, this court is inclined to hold that the order impugned insofar as the request of the petitioner for issuance of transit passes was turned down needs to be revisited by the authority. I think no separate representation is required in this case. Let the authority revisit this.
My lord, kindly allows the respondent number 5 to consider.
My lord, revisit will give, given by the district level authority. My lord, the principal secretary is the highest authority. My lord.
The same person should
Same.
revisit actually. The district land reforms
My lord,
officer.
in the event the same person revisits, they are coming up, already they are coming up, and your lordship has already observed that I am actually entitled to the transit
Do
passes.
you want to come up with a fresh representation before the higher authority?
My lord, one thing I would like to.
Because if I set aside this order,
Yes.
then the same person has to revisit.
My lord, let me kindly set aside this order and I will come up with a fresh representation. Or, my lord, since what I beseech your lordship is seeing that there is an entitlement of the transit passes on the face of it. In the event your lordship sets aside the order and directs the authority to issue the transit pass for that period, for that September, October, November, December, January, February. And March, I have prayed in terms of the order of this honorable court that physical possession was handed over after a month.
The authority has to decide. The
And
court cannot
my
give
lord,
a
that
direction.
apart, at least for 5 months, I am blatantly entitled.
Let the authority decide.
decide.
Let them revisit the matter.
My lord, kindly set aside the order.
It will be set aside
Yes.
only to that extent,
Yes.
and let the authority revisit. কি বললাম last time?
না, only শুধু ট্রানজিট পাস যেটা ইয়েতে ছিল, লিস্ট পিরিয়ডের মধ্যে ছিল।
Paragraph. Accordingly, the order impugned dated 3rd June 2022 insofar as issuance of transit pass was refused by the authority is set aside. The concerned authority being the
Respondent number 3, my lord.
My lord, the respondent number 3 has got the delegated power of the respondent number 5. In the other writ petition, in view of the new policy, since your lordship directed the respondent.
that's a different, it's little
No,
different
that is
from
with
this one.
regard to the renewal, and this is a delegated power. Let that the fresh representation be
That is
considered by
a
the.
fresh, that is a fresh consideration.
Uh-huh.
Here you don't need to file a representation at all. Let
Yes.
them revisit in the light of the observation made in the order.
My lord, again, the same thing will circulate again and again.
Same thing may happen if fresh representation is also given. So let us see.
My lord, they will,
Keep-
now they will incorporate that extra excavation part in the order.
কি বললাম? Third respondent herein is directed to revisit the issue of issuance of transit pass in favor of the petitioner during the for the period of validity of the lease in the light of the observation made in the body of this order. Stop. In dealing with the said issue, comma, the third respondent shall give sufficient opportunity of hearing to the petitioner and then petitioner and dispose of
Will be issued.
and come to a reasonable finding within 1 month, from the date of communication of this order.
My lord, earlier.
Stop
your lordship-
the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Earlier, your lordship
was
had
the-
passed an order while the writ petitions were pending that it is expected that
Yes, yes.
the transit pass will
An
be issued.
expectation is not
And,
a
and
direction.
the expectation of this honorable court was not appreciated by the same authority.
For a different reason altogether. He has given
Right.
an explanation to this.
Explanation, now they will come up with the
Which
explanation of
may be
extra
right or
excavation.
wrong. No, that
Well,
is,
that
that's
is-
a different procedure.
Your lordship kindly clarifies that.
If you have, how do I clarify?
My
this-
lord,
clarify
since-
this order?
Since it is evident to your lordship that I am entitled to the transit pass, your lordship can.
I have
direct-
recorded that in your order.
Yes,
order.
I am
I've
beseeching
asked
that
them to decide this in the light of the observation made in this order.
your
that
lordship
will
has
be
decided that I am entitled to it.
Let's see, that
For
should be sufficient.
5 months transit pass is, your lordship can.
My lord,
direct
instructions
order.
may be taken on record.
That শুরুতে করুন। Written instructions submitted on behalf of the respondents is taken. Submitted on behalf of the state respondents is taken on record.
Grateful to this.
Not to take my duty, no, no. Great, obliged.
I- আচ্ছা ওটা 6 weeks করুন 6 weeks করুন সেকেন্ডটা প্রথমটা 6 weeks করেছে না প্রথমটা 6 weeks এটা 6 weeks করুন yes next
Item number 9.
This is my application. My lord, this matter was mentioned yesterday. And it has been listed today. My lord, on the last occasion, it was taken up on constitution 17th of August. And learned advocate for the Union of India appeared as also the learned advocate for the state appeared. So therefore, well, may I submit
You are appearing for the petitioner?
lordship? But what I intend to say is this, since they appear and today.
I'm for the state.
Appear for the, but the learned advocate for the Union of India, he prayed for time to take instruction. Therefore, what I intend to say is that I will serve a copy upon him and then.
Railways is appearing in this one.
My lord, I am 11 and 12, I am for this statement.
9, 10, 11, 12. These are identical matters. Well, these matter relates to.
This
This-
is 9.
Yes, yes.
I'm not
Well,
hearing on
We're
that.
not in 9.
As all the matter are similar.
Here it is only the railways.
Yes, my lord. Realize that way I am the competent authority. I am.
Well,
That
the-
ATM is the competent.
petition
authority.
has
Additional
Yes,
is-
according to the-
Additional district
Yes,
magistrate.
my lord.
Well,
Additional district magistrate is
the
the
petition of land,
competent authority.
petitioner's land was acquired by the in a railways for the purpose of a special railway project in the district of Badwan. Now
Mr.
West.
Shobhasati Roy Choudhury was appearing for the railways.
My lord, he should be.
Today I do not find him.
Well, what has happened?
Did you put the other side on notice?
No, my lord. That's why I'm.
Then
Well, let it appear on Monday. I will come back.
not Monday, I'll fix a date. Please inform
Please,
them.
please. I'll kindly do that.
None appears for the railways. Paragraph, let the matter appear under the same heading on 27th June.
27.
Paragraph, the petitioner is directed to serve notice upon the railways intimating the adjourned date.
At number 10,
My lord, I have 9, 10, 11, 12 identical matters.
Same order in 1911. Give your name.
27.
11 and 12, Mr. Day.
11, 12, I am. In June.
27.
compensation good হবে the direction তো করে দিই ওইটা স্পেশাল ল্যাঙ্গুয়েজ number 13 lordship well I beg to appear on behalf of the petition
Yes.
dada
Mr. Bandyopadhyay, what state?
my lord kindly come to page 24
Page 22.
Okay, page 24, 23, so also on the same letter has been issued by the executive engineer to the land acquisition collector to the expedite the composition of the land acquisition.
What is the matter about?
Matter, my lord, his land has been acquired by the body construction of the road in the year of 1985. Thereafter, my lord, the petitioner award proceeding has been initiated. Award has been, my lord, the acquisition proceeding has been published. Thereafter, my lord, no compensation has been awarded. My lord, he's, my lord, made a first RTI letter complaint to the, my lord, the authority. That is, my lord, the page, my lord. Page, my lord, the 22. First, my lord, he wrote a letter to the executive engineer, highway division, for regarding compensation. Thereafter, for the effect of this letter, my lord, he made a RTI on my lord, page 23, 26, 8, 2022. Thereafter, they made a reply and are asking to the client to my lord to submit all the legal year certificate as well as the photocopy of the Aadhaar card and other documents. He has supplied all of them. Thereafter, the matter has been kept pending before the my lord land acquisition collector. And lastly, my lord, he made again, my lord, the page, my lord, kindly come to page 30. 26 September 2022, the RTI application they replied that the possession has been taken on 4/9/1985 and the 0.43 acre of land has been involved in the case mentioned above. Lastly, my lord, he made again RTI, my lord, 4/11/2022. Thereafter, my lord, the authority is tied over the matter.
You have come against an RTI, the writ petition. How is it maintainable?
My lord, the writ petition, my lord, lastly, my lord, these findings, no authority has been given any answer to this.
If
My
you
lord,
do not
it
get
has
an answer, there is you have the
the
appellate forum.
appellate authority, there is the appellate authority,
Yes.
but I prayed for my lord, land acquisition collector is the case pending for since my lord, the 2020 to 27-22, thereafter no response as yet.
What is your prayer? Your RTI has not been responded to. That is your prayer in the writ petition.
That is my lord, the.
Can the writ court intervene?
My lord, this my lord, kindly direct to the land acquisition collector to expedite the proceeding also.
The RTI proceeding, the RTI reply.
RTI proceeding, my lord, the different statutory appeal, but in this matter, my lord, the compensation of the land is not decided.
What is your prayer?
My PR is my lord, respondent 5 to pass an award in LA case number such pending before your authority and directing the respondent number 5 to make compensation to the petitioner in terms of the LA case number such and such, and directing the respondent to pay the compensation for acquisition of land pertaining to RS plot number and police station number Jogotpur is connection with LA case number.
Will you file a representation before the authority?
Lastly, my lord, I filed a representation, my lord, the page 22, that is the 18/7/2022 last complaint for land acquisition.
Will you file a comprehensive representation before the authority?
Comprehensive representation, nothing. That is what last, my lord, he has made it page 2022.
Page?
Page 22.
So, let the authority consider this representation.
No, that has not been, my lord, not considered, my lord, that have been instructed to the, my lord, the executive engineer, that is, my lord, 27/2022 to the land acquisition collector to taking effective steps for disposal of the same. That is, my lord, the with the above mentioned subject and reference, the undersigned is submitting here with the letter along with its enclosure, which is received from Srimati Kalpana Khan and 5 others towards compensation of the land acquisition in connection with the construction of the Pathial Kandakhat Road extension up to the Rajapur Canal in favor for kind disposal.
Mere communication is not extending the family to petition.
This was forwarded to the land acquisition collector. After that, nothing has happened.
Nothing else.
Yes, Mr. Bandyopadhyay.
No, the land has been acquired in the year 19. That is in the name of the. Sorry. He has made the application, my lord, there is no receipt, nothing has been. Although, my lord, it appears from the annexes, my lord, his application for. It has been made to the executive engineer, Howrah Higher Division.
Who has forwarded it to the land acquisition collector?
Yes, but there is no mention about the land acquisition proceedings. No dag number,
This
nothing.
LA case number, DAG number is stated
In
in
his
the
application, he has not mentioned.
pursuant to the application. This has been forwarded
Executive engineer forwarded to the LA collector.
with all the details.
That is important.
So let the LA collector deal with it and come to a finding.
But that has been decided, my lord. My lord, also can't turn to page. Last page. No, no, it is. Last page. 30.
Yes, 30 the Chabis my price.
Connection of the RTA application, my lord.
Page 30.
It appears that the land has been acquired.
Paste up.
Reply to the RTA.
He says that compensation has not been paid. He has filed a representation which has been forwarded.
Thereafter, he has made another application for right to information act.
That is RTI.
That has not been disposed of. It is his allegation.
RTI, this court will not deal with RTI applications.
It will make an application.
Since there is
the
an,
authority concerned, let it be decided.
he has already made an application which is pending before the authority concerned.
There is no mention, there is no land.
No, everything is mentioned, page 24.
that is forwarded by the executive engineer mentioning all these. But in his
Yes.
application, he has not made any tag number, any particulars of the.
Not required, Mr. Bandyopadhyay, you have taken steps.
You have to take my lord.
So this is pending before the acquisition collector, let him take a decision, let him decide the application. Affidavit of service. The petitioners claim to be the recorded owners of the plots in question and complain that though the said plots have been acquired by the state respondents, no compensation has been paid to them till date. Stop. In reply to an application under the Right to Information Act 2005 made by the petitioners, the Special Land Acquisition Officer within bracket General, Howrah, by a letter issued on 26th September 2022, informed that possession of the plots in question was taken on 4th September 1985 and 0.43 acres of land was involved in the LA case, being number 03 within bracket Act Roman 2 bracket closed of 1985-86. Stop. The petitioners submitted a representation requesting payment of compensation before the Executive Engineer, Howrah Highway Division, PW within bracket roads, bracket closed Directorate, Howrah, on 18th July 2022, which was forwarded to the Land Acquisition Collector within bracket General on 22nd July 2022. Stop. The petitioners submit that no further step has been taken by the concerned authority till date. Paragraph. Upon consideration of the submission made on behalf of the parties and material on record, this court is of the view that the concerned authority, since the representation made by the petitioners is pending before the Land Acquisition Collector within bracket General, being the 7th respondent herein, the said respondent be directed to consider and dispose of the representation within 1 month, within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, in the event the petitioners are found entitled to compensation, such compensation be disbursed in their favor within 1 month thereafter.
Since no affidavit has been called for all the
That is
allegations.
That's the usual line that is recorded now.
No, 14.
I am for the petitioner.
Yes.
Matter is very short and simple, my lord. The petitioner's premises is adjacent to the.
You are appearing for the petitioner?
Yes.
Respondents?
I am for the Jila Parishad.
Respondent number 7 to 10, Lordship.
7 to 10.
Private respondent number 7 to 10.
What about the state? Have you served the state?
Affidavit of service.
No one appearing, Mr. De. May I request? Yes.
Along with adjacent to the Paka road. And therefore, my lord, petitioner is involved and is engaged evidence. But my lord, private respondent constructed Paka structure obstructing the ingress and therefore, the petitioner, my lord, made a representation.
Exit hooks.
But he did not, my lord, consider it. Therefore, my lord,
How much I this?
It's PWD road.
Yes.
No. Lordship, road belongs to Lordship Jila Parishad. When Lordship, no representation was made before the Jila Parishad. What happened, Lordship, kindly consider Lordship, page 16, annexure P1. Since Lordship 1986, Lordship, with the permission of the father of the present petitioner, Lordship, the private respondents are reciting their Lordship. And there are, initially, Lordship, it was JOL as classification. It was thereafter, Lordship, in the 2022, it was converted after Bastu. It was totally private land over which, Lordship, the private respondent are staying. They are, Lordship, trying to evict, Lordship, by way this writ application without filing a civil suit before the proper forum.
Page 21 is the, my lord, record of rights, my lord, that belongs to the Jila Parishad. My lord, kindly come to page 21. Now, from his abutment at paragraph 8, he's saying that there is a vacant space in between his house and to the road, and his, my lord, which are lying idle after erection the said road as their ingress and egress is being hampered. The frontage of the petitioner premises, even if the vacant portion of the said road land belongs to the government, it is used by the petitioner as their easy access for going to and fro coming from the road to their premises. But after the private respondent are unauthorized to occupy, my lord, they are not unauthorized occupants, they are the leaseholders, my lord, of the said land. My lord, now, my lord, there are alternative way, my lord, through which he can come to the petitioner can come to the, my lord, main road.
The private respondents are occupying government land
Yes, yes, my lord, they are the, my lord, valid, my lord, leaseholders.
of the
Because
said land.
Of the, my lord, Jila Parishad.
My lord, I do not know.
So please come
Whether
back
they
with
are
the
the leaseholder
documents.
Yes, yes, I have the documents.
We have received the document, Lordship, but I am not carrying it to the Lordship. We take that matter tomorrow.
So will you
Lordship.
come back with a report in that case?
Yes, yes.
If the government has granted lease?
Yes, yes.
Government. But for what purpose? My lord,
The Jila, the land,
No, 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 my
the
lord.
land belongs to the Jila Parishad. As such, my lord, they have given lease to the of land to the, my lord,
What
private
purpose, my lord,
respondents.
they have, my lord, got the lease. What purpose? My lord, they have
The writ
taken
court
it.
will not decide on that, sir. The civil court will decide.
My lord, now he is having an alternative, my lord, way, my lord, to access the main road. My lord, now he is using, trying to use the, my lord, land of the Jila
If it
Parishad.
is encroachment on government land,
My lord,
even if the petitioner has alternative way, it is an encroachment.
my lord, encroachment.
Section 10
My
can
lord,
be
I
invoked.
agree, my lord.
But if you say the government, the Jila Parishad has granted a lease in favor of the private respondents
In his own land.
in the Jila Parishad.
Jila
sir.
Parishad.
So please come back with a
lord.
document.
Lordship
road
knows
or
that
not?
in
Yes,
terms
my
of the Lordship Highways Act also, there is a provision for
As per
granting
the-
permission.
Yes,
As
section
per
8.
the, my lord, land is concerned, my lord, there is nothing sort of, my lord, this, my
No,
lord.
if there is no illegal encroachment,
Yes, illegal encroachment to the in respect of the road. My
yes.
lord, whether it has
yes.
been obstructed or not. My lord, I will submit a report,
It's government land.
but he cannot, my lord,
Government land,
use.
if the government has granted lease in favor of the private
Yes, he
respondents,
has no authority to use
my
that portion.
No, my lord, government has not.
and if you want to challenge the lease, you have a separate forum
No,
for
no,
it.
I do not know that whether
Let
they
him come back
have,
with the report.
my lord, but they submit the paper.
Let him
My lord,
come back with the
My lord,
report.
my lord, now, my lord, it was, my lord, leased out, my lord, in the year, my lord, কত সালে দেয়া ছিল? It was most probably in the year, my lord, 2000.
Yes, but that should come on by way of an affidavit.
Yes,
If you Lordship direct, we can Lordship by way of affidavit Lordship. Can you
yes, we can,
we
my
can
lord,
file
file
Lordship,
that.
opposition.
Jila Parishad's affidavit should be sufficient.
We will filing a report.
Just a report in the form of an affidavit
Yes,
showing the
yes.
documents.
Yes.
Affidavit of service. None appears for the state respondents despite service. Mr. Dev is present in court, regularized quorum, copy service. Please serve a copy of the writ petition to Mr. Dev.
My lord.
A copy of the writ petition
Yes,
to
yes.
Mr. Dev.
And, my lord, I will indicate in my report, my lord, whether there is any, my lord, encroachment of the road.
Absolutely.
No, my lord, even if it is land belongs
His
to Jila
house.
Parishad, my lord.
Jila Parishad's
The-
land,
the issue
my lord,
here is-
thereafter the road. My lord, he cannot jump, my lord, over my land, my lord, and get access to the main road, my lord.
No, jumped. Why jumped? Mala, it is the frontage of the petitioner premises.
No.
It is the frontage of the petitioner's
It
premises.
is the
Mala,
Jila
he is
Parish-
bound to use that frontage.
admittedly Jila Parishad's land. If the Jila Parishad has allotted it to the private respondents, you have to approach the appropriate forum.
Civil court.
If that is
That
a
it-
road, my lord, if
Yes.
that is a road, my lord, he has not any authority to give him any.
So let him
He's
come
right.
back. Whether it is.
No,
a-
I have not given,
No,
no, I have not
If
given
that is a
lease of the
my lord,
road.
In
It's
another
my
case,
land.
my lord, your lordship knows very well, that is in Nadia district, my lord, that is municipality, my lord, in the road, my lord, they, in the name of the municipality, my lord, they issue lease. to
My lord,
the private
here, my lord,
respondent.
the road
That
was not leased. Here, the land was
The land
leased.
was.
If
So that has to be
land
seen.
is road or otherwise, my lord, that will
That
be
has to
That
be
we,
seen.
we will indicate in our report. My lord, how can a road be?
Mala,
leased out?
it is the, my lord, after making the road, certain some portions are lying vacant for, my lord, pedestrian and, my lord, for future extension. And, my lord, if it is leased, my lord, how the, my lord, government.
It is the Jila Parishad's land,
Yes.
and if the Jila Parishad has leased it out to the private respondents, you have nothing to do.
Yes.
What you can do is you can approach the civil
Civil.
court for your easement rights.
My lord,
The writ
kindly,
court
my
cannot
lord,
deal with it.
No, my lord, kindly.
Let him come back with the report,
my lord,
sir.
kindly
Why are you
section-
in a hurry?
My lord, kindly section 3. My lord, kindly section 3. My lord, if the Jila Parishad or any other, my lord, SDO is, my lord, informed that certain some portion is, my lord, covered by way of construction paka structure, then, my lord, SDO will, my lord, initiate the proceeding
That is if there is illegal encroachment.
of the road.
If the government themselves have, the Jila Parishad has allotted it,
There are also
there's no
provisions
illegal
regarding
encroachment.
necessary
Let him come back with
permission.
the report. Let him come back.
I don't mind if the matter, my lord,
Service এটা regularize করুন। Paragraph.
ঠিক আছে,
The petitioners complain that a portion of the government road has been encroached upon by the private respondents by raising unauthorized construction therein. Stop. Paragraph, it is submitted on behalf of the private respondents as well as the Jila Parishad that land belonging to the Jila Parishad adjoining the property of the petitioners has been leased out in favor of the private respondents by the Jila Parishad. Stop. Learned counsel appearing for the Jila Parishad seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter, please serve advance notice. Let the matter appear under the same
My lord,
heading on.
kindly grant me leave, my lord, to adduce the party Jila Parishad. Kindly
Jila
grant me
Parishad
leave.
is a party.
Kindly grant me leave.
you have made me a party. Executive officer has been made party.
Executive officer.
5.
Jila Parishad is already a party.
Yes,
Number
yes.
5.
Executive.
Yeah. My lord, he has
Come back.
yes, by name, my lord, he has not made the Jila Parishad the party,
Not
but the
necessary.
officer.
This will suffice. 26th June. 26.
My lord, in leave of 26th or 25th.
25th. I will not come to court. It's a Sunday. Will you come?
I will.
25th is a Sunday. Next.
Number 15. Madam for the petition.
My lord, in this matter, I am appearing for state, my lord. If it pleases your lordship, may I ask for accommodation for this week, my lord?
Who is appearing for the Union of India?
Madam, I've served all. They have received. Here is my previous service, madam. The state
The
is the-
answering respondent
is the
should be
state.
the state.
State.
He is asking for accommodation.
As your lordship, I'm not.
Affidavit of service. On prayer of the state respondents, the matter is adjourned. Let the matter appear under the same heading on 3rd July.
Well, third, you have not kindly short date because it was mentioned on my,
26th June.
but can it be on, because it's not mentioned on my instance, my lord. It
Then
was
it will come
running in the
back on 21st June.
as well. Also.
Much obliged with your kind leave, my lord.
Number 16.
This is my reputation. My second round of reputation also before your lordship. First reputation,
Respondents,
my lord, first reputation was taken up by your lordship. In the first reputation, there is no private respondent. In the second petition, there are 2 private respondents. Well, unfortunately, my lord, I have lost the tracking report of the private respondent. If your lordship thinks,
so will
my
you
lord,
serve afresh and come back?
my lord, my lord,
Will you serve afresh and come back?
press only, my lord, notice, only notice. Reputation I have served on 15 February.
Please show me the service.
My lord,
You say you have lost the track reports.
I have lost from my own custody. I have lost it from my own custody. Others official person, my lord, they have received by hand.
So please make a fresh service.
Press, my lord, only notice that
By notice. I do not know whether they've received copies.
repetition. Yes. Give me the third time, my lord. My lord, except the
Let
third
him
week.
come back after service.
My lord, except third week, my lord, third week I may not enter, third week I may not come.
Since service upon the private respondents is not complete, comma, let the matter stand over till 27th.
Yes, my lord. Yes. Yes.
Please complete service in the
Yes,
meantime.
yes. Well, everything has been completed, but unfortunately I have lost it from my own custody
27th.
on 27. Yes.
And number 17.
17 mala appearing for the petitioner, mala. If you will service to that?
Yes.
Yes, mala. But this is in respect to mala illegal
You
encroachment.
serve?
Yes, it has been served. Mala.
Several private respondents, all of them served.
But this is in encroachment section 10 of the mala. West Bengal
Yes, but
state.
you need to serve.
Yes, it has been served, mala. I have served. And if in service is there, mala.
Yes, Mr. Dev, may I request you? Please serve a copy to Mr. Dev.
Yes, so only mala, the state can come with a report, mala, because I am on the encroachment that is a mala, government land, mala. They are constructing shop owners and they have already mala, stopped my ingress and egress. Mala, I cannot go to the highway. Mala. That is my only point. Lordship will kindly takes mala, page 14 once, mala.
This is under the 62 Act.
Yes, yes. No, but this is under 56 Act. Mala. West Bengal Highways Act.
56.
Yes, 56. Yeah, encroachment. Mala, Lordship will kindly see.
What is the title suit about?
Mala, suit, mala, it's a totally different. Mala, I am only on a position that my ingress and egress has been stopped. Mala, if that is a government land, mala, that I am entitled. Mala. That has to be mala, mala, demolished and mala, section 10 proceeding has to be mala, taken care of. Mala. Mala, that is in respect to private
This is
property.
not encroachment upon a highway, it's private
No,
land.
mala, it's mala, adjacent. Mala, some private property mala, that has suit has been filed, and this is the portion mala, which has been encroached in respect to mala, the ingress and egress, the front portion.
PWD road.
Yes, yes, yes. It's a PWD road. But for that reason, mala,
Considered by the, after mala demarcation by the BLR, that will be done.
mala, state will file a report. Mala, if this is a PWD road, mala, then section 10 proceeding has to be there. Mala, this
So
is
it will be done. If let your representation be disposed of.
mala, representation. Mala, already mala, it's pending. Lordship will kindly cease from when, mala. It's pending since 2020. Only
So-
consideration, lordship will, lordship.
Consideration includes everything,
Yes,
including
yes.
section.
What has fallen from your lordship, then let state come, I'll argue on that point, your lordship can, if it is.
Argue on which point?
Well, on the point, if the state comes with a report that it is a PWD road and my shop, my
Why- why-
entrance has been
is it
encroached,
pending?
your lordship can direct here from that section 10 proceeding may be initiated from here only. Because that will again time, take.
Well, I'll record if encroachment is found, section 10 proceeding will be initiated.
That can.
Yes,
Yes.
that is the procedure.
Inspection,
section
by.
No other option, sir.
In the
No,
presence
I
of
am
the
only
petitioner,
on that,
madam,
if,
will be done.
if the report comes that this is a PWD road, your lordship can direct, section 10 proceeding can be initiated immediately.
In any event, this court can direct, isn't
Yes,
it?
yes, that can.
Yes. ma'am.
Affidavit of service, none appears for the private respondents despite service. For the respondents despite service, Mr. De regular school, office officer direction. কেউই আসেনি, কোনো respondent ই নেই।
মক্কেলকে বলে দেবে যেতে দিবেন।
The petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD road adjoining the petitioner's plot, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation in this regard before the concerned authority on page 13 is your representation?
13, 14 and 15, madam. 13, 14 and 15.
Assistant engineer is 14.
Yes, ma'am.
So let the page 14 representation be considered.
Yes, madam, 14, madam, and BLRO has to be there also, ma'am.
BLRO to report them.
Yes, the BLRO
Assistant
also.
engineer will direct the BLLRO. That's the process.
Assistant engineer.
What is the date of your representation?
Madam, it's date.
17th February.
Yes, yes. Madam, its first one is lordship will kindly see, my lord. Madam, my first representation is at page 13. Like it's at. Yes, yes. Madam, date is, madam, it has been received on 2019. It's the last bottom one. And madam, after that 2020 and last one is 2022. 3 representations, ma'am.
The petitioner submitted several representations in this regard on December 2019,
Yes, ma'am.
17th February 2020, and 11th, this is
Yes, madam, it's on 11th October 2022.
11th October 2022
Yes.
respectively, which are yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest and initiate proceedings under section 10 of the West Bengal Highways Act 1964 for removal of the unauthorized encroachment made by the private respondents. Paragraph, it is submitted on behalf of the respondents, the state respondents, that the
Respondent 3, my lord.
Respondent
third
number 3.
respondent be directed to
Okay.
consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representations submitted by the petitioner within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Paragraph, in the event illegal encroachment upon PWD road or any portion thereof is detected upon demarcation, the concerned authority shall initiate proceedings under section 10 of the West Bengal Highways Act 1964 and take the proceeding to its logical conclusion within the time period mentioned above.
Grateful, ma'am. Grateful.
Disposed of.
Xerox করে দিয়ে দিস। ছবি তুললে হবে না, জেরক্স করে তোরটা দিস তাহলে তাহলে
Number 18.
Hello, I am for the petition. I am for this case. Now.
Yes.
Hello, there is no private respondent. My lord, this is the sequel to the first round of litigation. My lord, I am the successful bidder for a Jolkor. My lord, the Jolkor area is 36.53. My lord, when I went there, my lord, I have found that the Jolkor area is much lesser than the actual that was floated in the tender. Now, my lord, then my lord, I have made a representation to the authority to ascertain the actual area of the Jolkor, and in the event they found, my lord, the Jolkor area is much lesser than the tender floated area. My lord, they should deduct the my lord, rent in proportionate amount. My lord, that was not considered. My lord, the first round of litigation was cropped up. My lord, kindly come to the page. Page 70 to 70, page 70. It was my lord's own order. My lord, operating portion is page 71, paragraph 3. Now, my lord, yes. What happened, my lord, on the basis of the inquiry, they had found, my lord, yes, my lord, the cultivated area is much lesser than the actual area that was, my lord, mentioned in the tender. My lord, this is the order page 75. My lord, 15th of September 2022. If my lord will see the page 76. My lord, may I read out?
Give a minute, please. Demarcation was done.
Demarcation was done, and my lord, on the basis of the demarcation and on the basis of a joint inquiry, they had found, my lord, yes, cultivated area was much lesser than the actual, my lord, tender floated area. And my lord, they had recommended that my rent amount they should be deducted in accordingly. Now, my lord, and they had sent it to the district Jolkor committee. Now, my lord, on the very date, my lord, I have made a representation, another representation, my lord, saying that your my lord, actual ascertained area about 32.52, that should be, my lord, and there should be another deduction, because my lord, 4.64 area is a patta. Out of, my lord, total cultivated area they have found, but there is another, my lord, 4.64 a decimal area is a, my lord, patta area. This should also be, my lord, considered, and my lord, the proportionate rent should be accordingly, my lord, deducted. And my lord, page 78, kindly consider, my lord, we on the very same day, my lord, I have made the representation to the authority.
73.
My lord, 78. After the order passed by the my lord, ATM DLR, page 78.
Yes.
Here, my lord, we have specifically mentioned that what you have found, there should be another deduction of 4.64 decimal, because that is admittedly a patta. My lord, we have thereafter, my lord, if my lord will see page 79 onwards, I have given the details of the patta. 79 up to 84, 85, and my lord, 87 is the record of right.
This is out of the 23.73 decimals.
Yes, my lord, that is 32.53. They have found this cultivated area. My lord, among these, my lord, this 4.64 decimal is the, my lord, patta area. And this is admitted position, page 87 is their record of right. Now, my lord, thereafter, my lord, kindly come to page 93.
Yes.
Jalkar committee, my lord, had considered the rent on the basis of their actual cultivated area that they had found, my lord, in their, my lord, hearing. 32.53. They had considered and they had, my lord, fixed the rent accordingly. That is 10,48,000.
and odd, my lord. It will be, my lord, enhanced thereafter, my lord, from 1430 to 1431, 5% increase. Now, my lord, what happened? I am seeking revisit of the entire thing because, my lord, this 4.64 has to be, my lord, deducted because this is a admitted position. My lord, and on the very, my lord, I have made the contemporaneous, my lord, representation to the authority. That was not considered. And, my lord, kindly come to the last annexure, page 102 is the latest representation. 102.
Give me a minute, please.
Yes.
ADM.
And, my
This
lord,
order was after your representation.
no, my lord,
Page 93 order.
page 93. Page 93 order, my lord, it was when the hearing order was passed, immediately, my lord, I have filed the representation. Before the, my lord, ATM LRO. But this order was thereafter, my lord, there is no, my lord, mention by reflection, my lord, that whether my representation was at all considered.
That is exactly what I'm saying. This is
Yeah.
after your representation.
After
as
your
well.
representation, now, my lord, it is without considering that particular, my lord, objection that I have made. And, my lord, what I am on, my lord, I am, my lord, as on date, my lord, subject to correction, I am entitled to for further direction because that is a admitted factor. And, my lord, to that effect, I have made the comprehensive representation. That is the last annexure. My lord, if my lord will see 104, paragraph 2, I have given the details. Why I am seeking, my lord, that further direction. My lord, I am only praying, my lord, these aspects to be considered by the authority and they should take a decision. And
102 is a detailed representation.
yes, 102, and I am showing the 104 is the, my lord, the crux of the representation. 104, second paragraph.
That's
That
all.
will be
Yes.
considered.
Yes, my lord.
That will be considered.
My lord, what I am
Because,
making,
my lord, that land was not with him, my lord, so that should be considered.
my lord, there should be a final resolution, my lord. Immediately I am coming, because I am not yet,
Final considering বললাম তো তারপরে
I'm grateful to you.
So let the representation be considered.
Let the representation be
I'll
considered.
state the facts before that.
Yes. And there should be a resolution, my lord, final resolution, because one after another I am coming, my lord. Till date, I am not my lord, able to enjoy the jalkar. আমি অবশ্যই এখনই দিয়ে দিচ্ছি।
Affidavit of service. The petitioners
দাও নামটা কি?
this was an e-auction.
This was a tender, my lord. It was not the e-auction.
It was a tender.
Tender, my lord. I am showing the
But
tender
the
document.
Successful bidders in the tender
48.
floated for settlement of Boalmari BOAL, Boalmari BOAL, Boalmari Shuti Jolkor, SUTI, Jolkor, comma, the Jolkor was settled in favor of the petitioners by virtue of a deed of lease for a period of 7 years from 1425 BS, 25 BS to 1431 BS upon payment of annual lease rent. Stop. Upon settlement of the said Jolkor, the petitioners learned that though the tender comprised 36.23,
Yes, my lord,
36.23 acres, the actual area of the Jolkor handed over to the petitioners was 23.73.
Yes.
23.73 acres. Stop. The petitioners submitted a representation before the concerned authority for adjustment of the lease rent in view of such circumstance. Stop. Paragraph. Pursuant to an order passed by this court on 12th August 2022 in WPA 16659 of 2022, directing the concerned authority to complete the process of demarcation of the Jolkor in presence of all the interested parties and thereafter consider the representation submitted by the petitioners for adjustment of lease rent, demarcation of the Jolkor was made and it was found that the Jolkor comprised 32.52 acres and not 36.23 acres. And the matter was placed before the district Jolkor committee for proportionate reduction in lease rent from 1429 BS to 1431 BS, by an order passed by the additional district and district land and land reforms officer, Malda, on 15th September 2022. Stop. It was also detected that out of 32.52 acres of the Jolkor, an area comprising 4.64 decimals was let out to
several persons.
Let out to several persons
Patta holders.
by virtue of pattas. The petitioners have also paid for exemption of lease rent in respect of the said area. The petitioners submitted a representation in this regard before the concerned authority on 26th September 2022. Following which, the additional district magistrate and district land and land reforms officer, Malda, by a letter issued on 18th October 2022, assessed recorded that the district Jalkar committee has recommended lease rent from 1429 BS to 1431 BS at rupees 10,48,491 with 5% enhancement from 1430 BS. The petitioners submitted a further representation on 17th March 2023 seeking reduction of the cultivable area of the Jalkar from 32.52 acres to 27.88 acres by deleting the extent of the patta land and reassess the lease rent payable by them. Stop. The said representation is yet to be considered. Stop. The petitioners pray for a direction upon the concerned authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the respondent number?
Respondent number 3.
District Land and Land Reforms Officer.
Yes.
Third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioners dated such and such. Huh? Huh? No. It is last 17/3/2023. 17th March 2023. Within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, and in the light of the observation made in the body of this order, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
My lord, may I make one prayer? My lord, only I am making one prayer that there should be a final resolution because my lord, only two years left. And my lord, since this entire period, my lord, I am not, my lord, enjoying the Jalkar, but I am giving the.
It has to be a final resolution.
Yes, my lord. If that
It cannot be an interlocutory resolution.
my lord, because my lord, what I am on, my lord, I should not come again to this, my lord, because I am repeatedly I am coming, though it is completely within domain of the authorities.
Let us see. That's why I've stated in the light of the observation.
Yes, my lord, that is.
Let us see.
I'm getting.
That might help you.
Yes.
Yes, next.
I'm getting.
Number 19.
Respondents, Mr. Butcher.
19.
Yes.
Petitioner is owner of plot number 1527.
Have you served the this is Moina Adursho Shikshayatan.
Yes, sir.
Where is your service?
Affidavit of service, affidavit is not ready, my lord. Service is
Come back after your affidavit is ready.
after, my lord.
After your affidavit is ready, you have to show service, isn't it?
But it was served, my lord.
Where is your
not ready.
affidavit?
Affidavit-
Come back,
my lord,
come
in
back.
course of today, I will.
Not today. Not today. Come back tomorrow.
Not today, go.
Yes.
Number 20.
20, my lord, in this matter, my lord, I am appealing for the petitioner, my lord. This is the affidavit of service. The original lessee, my lord, in Salt Lake property, my lord, died. Died interested living behind his two sons who are the petitioner before lordship. Upon death, my lord, an application was filed for mutation the land in their name. That, my lord, will find at page 10, annexure A. Along with requisite fees, my lord.
They are the legal heirs.
Legal heirs, son. At the page 10, my lord, your lordship will find Dilip Kumar Pal Chaudhary and Deepak Kumar Pal Chaudhary. They are both the sons.
Yes.
And this is pending for 2019. And the lease, my lord, I have annexed, my lord. If your lordship can turn to page 24. In favor of Dijodash Pal Chaudhary. And who died, my lord, on 8/6/2016. I have annexed the death certificate that is at page 21.
Your prayer is mutation.
Mutation. Mutation, my lord, my application has already is pending for consideration.
Yes, my lord. You'll also may direct the land manager to take a decision on the basis of the application.
2 weeks.
2 weeks. Respondent number 3 is the authority. Respondent number 3 is the authority, my lord.
What is your answer?
Heard learned counsels for the parties. The plot in question being plot number 13, block AJ, sector Roman 2, Salt Lake, Kolkata 7,91,000 was allotted in favor of one Dijodash Pal Chaudhary, DWIJA, since deceased, vide deed of lease for a period of 999 years. And after demise of the original lessee on 8th June 2016, the petitioners being his sons, stepped into his shoes. Stop. The wife of the original lessee
Died, my lord.
predeceased
The husband.
predeceased him on 18th November 2007.
18th November, my lord.
18th November.
18th.
Yes. The petitioners submitted an application for mutation before the land manager Vidhan Nagar, Department of Urban Development and Municipal Affairs, Urban Development and Municipal Affairs, Government of West Bengal, on
26/8/19, page 11. 11/9/2019.
26th.
No, it is
26/8/2019.
there's a relationship certificate. Next page is the relationship certificate.
Where
The
is
first
the-
page 10, my lord.
11/9, yes.
11/9/2019.
September 2019, which has not been considered as yet. Stop. The petitioners pray for a direction upon the concerned authority to consider the said application and grant mutation in their favor in respect of the plot in question. Paragraph, it is submitted on behalf of the respondents that third respondent is directed to
land manager.
consider the application in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the application submitted by the petitioners dated such and such, and consider grant of mutation in their favor within 1 month, within 2 weeks, I said.
2 weeks, my lord.
1 month is my lord.
Within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioners
Or their representative, because two petitioners.
/ their authorized representative, in accordance with law.
And to
The
communicate
decision
the
taken by
order
the
if
authority shall be communicated to the petitioners within a week thereof. Disposed of.
grateful to your lordship.
Number 21.
21, I am appearing for the petitioner.
21,
I am appearing for the petition.
sir,
for the,
Yes,
I'm for the
ma'am.
private respondent. I'm led by Ms. Sushmita Shah.
state.
My lord, here in this writ petition, my lord, petitioner complaint against the unauthorized construction made over the, my lord, public road, and for which, my lord, after taking consideration of the complaint, the authority concerned, my lord, or passed an order of removal of that structure. Challenging that, the private respondent came before this honorable court, and your lordship on that writ petition specifically directed that to initiate a proceeding under section 10 of the West Bengal Highways Act and conclude that proceeding. In terms of your lordship's direction, the authority concerned, my lord, initiated the section 10(1) proceeding. Assistant engineer hold that this is an unauthorized construction that passed an order for removal. In accordance with section 10(2), assistant engineer referred the matter before the subdivisional magistrate for passing necessary order for removal of construction. What happened, my lord, instead of initiation of section 10(3) proceeding under Highways Act, my lord, that subdivisional magistrate initiated a proceeding under section 123 of CRPC and passed an order that rejecting the claim of the writ petitioner that on another ground, my lord. Challenging that, my lord, the writ petitioner came before this honorable court on earlier occasion, and your lordship on that writ petition hold that as the section 23 CRPC proceeding cannot be challenged, order passed in section 23, 120, 133 under CRPC proceeding, my lord, cannot be challenged in a writ petition. That is why your lordship, we withdraw the writ petition and your lordship granted liberty to take necessary action against that order, my lord. Now I came before your lordship, my lord, for specific for direction upon the authority concerned, my lord, to conclude the proceeding under section 10(3) of the West Bengal Highways Act. Because 10(1) complied, 10(2) complied, 10(3) has not been complied. That has to be, my lord. Otherwise, my lord, section 10 proceeding has not yet been concluded, my lord. If your lordship kindly comes to the Highways Act, my lord.
Not necessary.
Not necessary, my lord. So my well, it kindly comes to page 27.
37.
27. This order was challenged in earlier writ petition, my lord, and it is an order under section 123 CRPC, and proceeding was dropped as it is a private interest was dressed up as public interest. The issuance of encroachment of Daulatpur, my lord, this is the order passed by the subdivisional magistrate. Prior to that, your lordship kindly comes to page 21. 20. Page 20. My lord, at the very beginning, kindly comes to page 20. Annexure P2. The private respondents on earlier occasion challenged this honorable court before this came before this honorable. Your lordship specifically directed, my lord, page 21. In view of the above, third respondents is directed to initiate the proceeding under section 10 of the said act and take the proceeding to its logical conclusion. Page 21. Within a period fixed by your lordship, my lord. What happened? Page 22. Proceeding was initiated under section 10. My lord, at the very bottom, now therefore, in exercise of power conferred by section 10(1) of West Bengal Highways Act, I hereby order you to remove unauthorized structure with all your properties from highway land within such and such, failing to which this department will be compelled to take necessary next course of action as per the said Highways Act. This is the order passed by the assistant engineer, PWD. Now, page 23. Not necessary, my lord. Page 25 kindly comes to. Under section 10(2), the said assistant engineer, PWD, my lord, approached the subdivisional magistrate for removal of unauthorized structure encroachment from PW roads bearing plot number such and such, Kotian number such and such. Order sheet of High Court, my lord, your lordship order was recorded. 10(2) to recover the possession. What he did, now page 27. He did, the subdivision magistrate initiated proceeding under section 123 CRPC.
which has no corroboration under the West Bengal Highways Act and that order passed under section 123 CRPC has no legs to stand upon, as the section 10 of the West Bengal Highways Act is a specific act and laid down the procedure how to remove the unauthorized structure, my lord. Then your lordship's order came, page 28. Your lordship held that petitioner has assailed the order under section 133 of the CRPC. Learned counsel for the petitioner seeks to withdraw the writ petition to approach the appropriate forum to challenge that order, my lord. That writ petition was dismissed as withdrawn. Now I came before this honorable court, my lord, before your lordship, for a direction upon the respondent number. The subdivision magistrate, respondent number
To
4,
conclude the proceedings.
conclude the proceeding under section 10(3).
Let us hear the
Yes.
state. Yes.
My lord. 10-3, my lord. Situation says and hearing to be given.
Let the proceeding be concluded upon giving an opportunity of hearing.
Yes,
Yes.
both of it.
How can 133 follow 10-2? I do not know.
The lordship has already passed the order as such and dismissed the earlier teacher.
The road under question matter, highway, that is not a highway. That is a pocket road. That is not a highway. Pocket road.
That has to be ventilated before the authority, because my lord, assistant engineer PWD road, he himself hold that it is a.
But that is not a highway.
Section 10-1 was initiated.
Yes,
You will have your chance under 10-4. That has been recorded in the earlier order also, isn't it? Affidavit of service. Heard learned counsels for the parties. Upon demarcation of the plot in question and detection of unauthorized encroachment thereon by the private respondent, comma, notice under section 10-1 of the West Bengal Highways Act 1964 was issued by the assistant engineer, comma, Bunyadpur Highway Subdivision, comma, PW within bracket roads, bracket closed directorate, comma, Bunyadpur, on 23rd June 2022. Stop. Further notice was issued under section 10-2 of the Act of 1964 by the said authority on
my lord, 22nd July 2020, page 26.
22nd July 2022, following which the subdivisional magistrate, comma, Gangarampur at Bunyadpur when was the 133 proceeding
Thereafter.
initiated?
Thereafter, after 10-2, the subdivisional assistant engineer referred the matter before the subdivisional magistrate for passing necessary order for removal of.
27, it is dropped.
Yes, he dropped the proceeding under 133 CRPC. That cannot be. 133 CRPC has no scope
When
under
was 133 initiated?
after 10-2, 22nd July, he referred the matter
22nd July 2022, he referred the matter before the
Yes.
subdivision magistrate. Then this order came 30th December 2022, page 27.
30th December drops the proceeding. When
Drops the
was-
proceeding.
So when was it initiated?
Oh, when was it
133
initiated?
proceeding.
My lord.
This order drops the proceeding.
Yes, my lord. It was initiated. 13th September 2022. As it was not legible, I have not annexed mine.
Following which, proceeding under section 133 of the Code of Criminal Procedure, following which, চলছে, না, subdivision কেটে দিন এটা. Following which, proceeding under section 133 of the Code of Criminal Procedure was initiated by the subdivisional magistrate, Gangarampur at Bunyadpur by an order passed on 13th September 2022. Stop. The said proceeding was dropped by a subsequent order dated 30th December 2022. The said proceeding, being misconceived, was dropped. The said proceeding, being misconceived, was dropped by an order dated 30th December 2022. Paragraph. The petitioner complains that the illegal encroachment has been made on PWD road adjoining her land, that is your case,
Yes.
thereby obstructing her egress and ingress.
My
Full stop. The petitioner prays for a direction upon the concerned authority to conclude the proceeding initiated under section 10 of the Act of 1964. Paragraph. Upon consideration of the it is submitted on behalf of the state respondents that the 10-3 should be by the subdivisional magistrate.
Subdivision magistrate. Respondent number 4.
That the fourth respondent be directed to take necessary steps under section 10-3 of the Act of 1964 upon granting opportunity of hearing to all the interested persons. Paragraph. In view of the above, this court is inclined to hold that since proceeding under section 10 of the West Bengal Highways Act 1964 has already been initiated, the concerned respondent being the concerned authority being the fourth respondent herein, be directed to take the proceeding to its logical conclusion within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, in accordance with law. Disposed of.
Grateful, man.
You can take back this document.
My
Number 22, my lord, I'm.
Much.
আমার mic লাগবে?
Yes.
My lord, this is the second round of litigation, my lord.
Respondents, Mr. Guchal.
My lord, I have served, my lord. All are appearing, my lord. The railways are appearing, the state is appearing. My lord, railway is the main respondent. My lord,
Kindly come to my lord page 43. My lord, kindly come to 39 first. That is your lordship's order. The entire matter was
The railway,
dedicated.
who is appearing for the
My lord,
railways?
senior.
You are appearing? For 4 and 5 both?
4 and 5. My lord, 4 and 5, my lord, senior friend.
But he is without instructions today. Let him come back.
Yes, my lord. With
Will
an
you come back with
instruction.
instructions?
My lord, here, my lord, short point is involved, my lord, for my lord, capitulation, my lord, that my lord's order was to, my lord, refer the matter to the special land acquisition collector. My lord, he took hearing of the entire thing, my lord. Now, he asked the railway to, my lord, appear before him and, my lord, submit the reports. My lord, in spite of repeated requests, my lord, it was not done. Ultimately, he came to a decision, my lord, you approach the appropriate authority. My lord, this is the order which I have challenged before the lordship. My lord, instruction has to be taken, my lord, whether the entire process of acquisition, my lord, which he has made, my lord, that has to be brought to your notice of your lordship.
Please come back with instructions.
Because we have, till date, my lord, we have not received any compensation.
So, after hearing, we found.
Yes,
my
yes,
lord,
naturally.
the land wasn't acquired by us. That is for the
Very true.
of the railway.
Was not acquired by the state.
Yes. That is not our acquired.
So the railway has to respond to this.
Railway has to respond. That is the-
Let them come back. Affidavit of service. For the Eastern Railway seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on
My
23rd
lord,
June,
later report be, my lord, filed, my lord.
23rd June. You'll come back with a report?
Report. Deeply appreciated.
You are 23. I am going to visit Mr. Mondoli leading me. That's what.
Pass over not possible in this court, I'm sorry. Make your submissions.
Construction over TWD land. Yes.
Where is the affidavit of service?
Service ready, my lord.
Nothing is ready. On prayer of the petitioner, the matter is adjourned. Please be ready when a matter is called, sir. You're wasting time.
Not to do, my lord.
No, not at all, because you're not ready with your brief. Such a short, simple matter, you're still not ready. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 20th June, 20. Next.
Very short matter, my lord. My lord, I have served my.
Where is your affidavit?
Yes, my lord. This is my all are served, my lord.
There are several private respondents.
Yes, my lord. Kindly see, my lord, my affidavit of service, my lord. Item was dispatched, my lord. All item, my lord, delivered. Delivery report confirmed, my lord.
Salema Bibi not served.
Only one, my lord. One on all dispatch, all are served, my lord.
So that is one which is
Yes.
not served. You have to serve and come back.
My lord, all
She'll
are
go up in
same.
appeal and say, I have not been served.
My lord, only for one person. Or
Yes, she's a person, isn't it?
all are family member, my lord. All are family member.
All are family.
Only
members?
one shop room, my lord, all constructed, my lord, in front of.
Very good, yes. Yes.
Yes, ma'am. Kindly come, my lord, of page 20, my lord. The representation and my lord,
PWD
reminder,
road?
my lord, page 27.
On PWD road.
Yes, ma'am.
Page.
Page, my lord, page 20, first representation, and my lord, 27, my lord, second representation. All I received, my lord, they have not taken any steps, my lord.
'27 is better drafted, so let 27 be disposed of.
Yes.
Consider.
They have not submitted the schedule. They are serving as the executive engineers. Still not the approved property.
I'll give a direction about the assistant engineer to. Affidavit of service. None appears for the private respondents despite service. Paragraph, the petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD road.
Yes, ma'am.
Road adjoining his plot, comma, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation before the concerned authority in this regard on
11th April 2023, madam.
11th April 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the assistant engineer is respondent number,
Yes, sir. Also not made a party respondent.
not made a party.
Yes, madam.
Please add him as a party.
Seventh respondent, madam, or madam, DM, madam.
No. Assistant engineer has to deal with it. So please add him as a party. একদম শুরুতে করুন on prayer of the petitioner. Liberty is granted to implead the assistant engineer. Midnapur Highway Division, what is the designation?
Assistant engineer PWD, but the division will not be we have to ascertain which division.
Yes.
Midnapur division.
Assistant engineer, Midnapur Highway Division. Highway Division, comma, Public Works Department within bracket roads, comma, Government of West Bengal, as respondent number 13
Yes, ma'am.
in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly. And it is submitted on behalf of the state respondents that the 13th respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the 13th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Disposed of, rejected.
The 24, madam, for the petitioner, madam. I am for the state. My lord, petitioner grievance is, my lord, on the PWD road, my lord, in front of my land, my lord, private respondent constructing the construction. That is why, my lord, I have the complaint before the appropriate authority.
You are for the private respondent?
My page 26.
Page 26.
Page 26, my lord, before the assistant engineer. That should be considered, my.
Mr. De?
Yes, ma'am.
Yes. Take the microphone, please.
My lord, the private respondent also, my lord, made a representation before the assistant engineer. My lord, that, my lord, the petitioner is also, my lord, made a illegal construction. My lord, kindly see the representation.
That is a
And
different issue.
no, my lord, the plot is, my lord, just adjacent to my plot, my lord. And my lord, the writ petition is, my lord, also ready, but my lord, due to, my lord, the technical download, the writ petition is not filed. If,
Petition, it will be considered separate. No.
okay, lords.
You are entitled.
My lord, if, my lord, your lordship, my lord, permit me, my lord, only 2 days time, my lord, then the both the writ petition will be. Only, my lord, adjourn this matter, my lord, then the both the writ petition will be tagged with the, and my lord, but my
You
lord,
have not filed, sir. It is a separate cause of action.
petition
And whenever you file a petition,
only, my lord, my humble submission before your lordship, if your lordship is, my lord, permit me to only, my lord, 2 days time, then the both the writ petition.
if it would have been filed, I would have granted you time. You have not filed it at all. Let this be disposed of. When your petition comes up for hearing, it will be dealt with.
Lords.
Affidavit of service. Same order for them. Petitioner, huh?
Respondent number 4.
না ওটা অ্যাড করতে না সিজন আছে এখানে অ্যাড করতে হবে না fourth respondent representation dated 17th April 2023 making 3 months.
Yes.
Next.
Good.
Number 25.
You asking for time?
I'm paying for an
You're
adjournment, paying for an adjournment for at least a week.
Very, very. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 29th June.
Number 26.
The 26 and 27 are similar matter.
Have you served?
Lord, I have served, my lord, so far 27 is concerned. Mr. Bandyopadhyay, along with my
26.
26, my lord, it may.
Where is your
26
service? I can request him to
Yes.
appear.
26, 27, both are same matter. This is regarding, my lord,
So Mr. Bottabal, will you please appear in this matter also? Please give him a copy.
yes, yes.
Yes, what is the matter about?
My lord, I was granted my release of sand in both the two cases. But my lord, due to COVID, we could not run. And number two, my lord, one Majar, my lord, was there, my lord. They, my lord, did not give us permission to, my lord, run our, my lord, lorries, my lord, within this territory. That's why, my lord, we made a prayer representation before the district magistrate, Bakuda, stating all such facts. Lord, we will appear from page 21. For extension of time period, we have made this. But my lord, no steps taken. My lord, in the next page, we have also made an application demanding justice. The
Where
same
is your
has-
representation at page?
Page 21.
Page 21. So let this be considered. Yes.
There is no provision of extension of my lord lease period. If you also direct the authority to consider, my lord, the authority will consider, my lord. But no provision or
Hear out the petitioner.
yes, my lord. After hearing, representation may be considered.
Yes, let it be
Well-
considered. Place your documents before the authority. Affidavit of service. None appears for the respondents. Mr. Bottabal, regularized quorum, copy service direction. It is published. Bottom date. 26. 26. The petitioner was granted long-term mining lease for excavation of sand. Deed of lease executed on 8th November 2016 for a period of 5 years. Stop. The petitioner was unable to continue with the excavation due to the COVID-19 pandemic and resistance offered at the instance of Bir Singhpur, BIRSINGH, Nirgin, NIRGIN, Nirgin Shaha, page 6 se ache. Shaha Baba Majar Committee. Stop. The petitioner submitted an application for extension of the lease period before the concerned authority on 24th November 2021, which is yet to be considered. Stop the petitioner place for a direction upon the authority to consider the representation at the earliest. Paragraph is submitted on behalf of the respondents that the district wise, the additional fourth respondent. The fourth respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month.
Yes.
From the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of. 27 same.
Same.
Date will be followed. Shantanu. Let it be done.
Construction of, due to construction of bridge, my lord, we could not, my lord,
Due to construction
of a bridge.
and COVID-19 also.
No, they have not stated in
No COVID-19.
Paragraph 8, page 6, they have
A
stated.
date of lease. Lease date was 22nd November 2016 for a period of 5 years. 22nd November 2016. The petitioner was unable to carry on mining operation due to
Paragraph 8.
construction of a bridge near the leasehold area for which the petitioner was directed to stop excavation of sand from the allotted sand block by the respondent authorities on an assurance to transfer the leasehold block to an appropriate place. I think it's not transfer of the leasehold, it's a granting an alternative block, isn't it? On an assurance of allotting an alternative block. Please stop them. On an assurance of allotting an alternative block. Where is your representation?
Page 64. Page 64 onwards, my lord. There are
The petitioner submitted several representations before the concerned authority for extension of the mining lease, which have not been considered as yet. You are asking for all the consideration of all the representations. The petitioner pays for the direction upon the concerned authority to consider the representations submitted by the petitioner on petitioner at the earliest. So, যেখানে submitted by the petitioner open bracket annexure P3 and P4 to the petition. Annexure P3 and P4 to the petition. Within 1 month. Happy to say. In this regard. Several representations in this regard. Yes, next.
Number 28.
My lord, praying for adjournment for the petitioner. Kindly the day after tomorrow.
Dates will be fixed by the court, madam. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 22nd June.
Number 29.
Hey, please, your lordship, this is my writ petition.
I beg to appear on behalf of the
Sir, state.
Yes.
My lord, initially, a writ petition was filed by the petitioners, my lord, challenging, my lord, the inaction on the part of the Gram Panchayat, my lord, in not arresting an unauthorized construction, which was, my lord, undertaken affecting the boundary wall of the petitioners on the adjoining, my lord, land.
There is a service.
My lord, my lord, both the respondents are appearing.
Gram Panchayat and private respondent.
My lord, the state is appearing and also, my lord, KMD is appearing.
Gram Panchayat and private respondent.
Private respondent has come back. It says that cannot be insufficient address cannot be served.
Serve and come.
And the address I've taken from the notice.
My lord, the
What
address, my
about
lord,
the
what had
front?
happened is the address I have taken from the notice of, my lord, hearing which was given to us. But we did not have the address otherwise.
Irrelevant. You have to serve and come. You have the substituted mode of service also if you cannot serve ordinarily. In any event, you have to serve, isn't it? What about the Gram Panchayat?
But possibly, my lord, the panchayat would not be necessary.
78.
But
You
may I
want to-
only indicate in a minute, my lord, why it
want
would
to delete
possibly
this?
not be necessary?
You want to expunge the name of the Gram Panchayat?
It can be done.
Can be done?
Yes.
So serve the private respondent and come.
presence of
We can
private
try and serve, but I do not know how to, because we have come to learn of the existence of the private respondent from the notice of the hearing, and we have given that same address where we found the notice. Otherwise, we didn't know who was carrying out the construction. That is the whole
The
difficulty.
private respondent, also the Gram Panchayat is necessary. I find.
Because Gram Panchayat has given a letter
Case 62,
saying that the land does not belong to us, it belongs to KMD.
how it can be. They have to explain that. I will also take
But
instruction.
then
I
we shall
got
serve the
this
Gram
tip
Panchayat.
yesterday. I also need to take instruction.
Gram Panchayat has been served. You've not checked.
Yes. But ये टका serve आएगी.
Private respondent is
So the private respondent is your only hurdle.
only.
I do not know how to cross that, but we'll try. Because that is the only address we know of.
I don't know whether Mr. Taludar can help you.
I do not think so. Because it was a hearing conducted by the Gram Panchayat at the office of the Gram Panchayat, where we found from their document a notice given to the private respondent for the hearing. In that notice, we found an address and we have added them as parties and given that address.
And they were present. It is,
And they were present in the hearing also.
Try if you can.
I shall.
it is the Gram Panchayat who contended that the land does not belong to them.
Gram
It is
Panchayat
belong-
has been served.
It is belong to KMD. That appears from page 62.
My lord, is it a lordship's pleasure to, my lord, indicate that we can also try and serve by hand?
I'll just say service. If you can prove service,
Very
I'll accept it.
I'm grateful.
Since service upon the private respondent is not complete, by hand is difficult. Who will identify? You take a signature
Because
of any
they are the
person.
ones who are present in front of my premises. So, my lord, we are giving them in the, we shall try.
I'll let the matter stand over till 27th June. Sufficient?
I was praying for some earlier date if it's so common.
Can you serve earlier?
But it's nearby. My lord, it's not that it's too far. It's near Barui.
Very well, 21st June.
Very well. I'm so
21st. Take it in.
Group 7 motion, item number 33.
33, my lord, in this matter,
Now, my lord, Lordship kindly appreciate one thing. This is from November.
he is,
It's
my
a
lord,
tax matter.
in-
Now, my lord,
in
the
an-
earlier occasions also took time.
in an
Then again, it is only to reply, give me. I have to reply, my lord, conclude.
Yes.
My lord, Mr. Sen has concluded, his junior is here. My lord, how long I have to wait, my lord, for only to give the reply, my lord?
May I pray for Passover, my lord, because my lord, Mr. Sen is engaged in courtroom number 13 in an urgent matter. That's my humble prayer, my lord.
Not today,
My lord, your lordship kindly from November.
tomorrow. I'm just making it not today.
Well, let it remain in its positions, my lord.
7 matters are very few.
Only this is first item today because tomorrow the next.
You have seen the list,
Most probably first item.
motions.
Item number 34.
None appears so the parties culpable. Dismiss for dismiss for. No one, none appears for the parties, no accommodation is sought. We dismiss for default. We appears from the conduct of the petitioner that is no longer interested.
Number 35.
For the writ petitioner in this matter. Lordship will remember this is a matter Lordship has heard on the previous occasion on 17th. My lord, petitioner is a registered leaseholder with the Indian Railways. Now, the Indian Railways has Lordship is
You're appealing? Railways, you're appealing?
Railways. The Railways, in the meantime, Lordship has introduced one e-auction policy, 11 of 2022. Under that e-auction policy, my lord, tender was floated. I took part in the bidding process. The bid which was submitted by me emerged as the highest one, and accordingly, an agreement was executed between me and the Southeastern Railway for a period of 2 years. My lord, that the agreement period is valid from 2023 to 2024, April. Now, my lord, I used to pay the advance freight charges at both the ends. One at the forwarding station at Shalimar, and another one is a CSTM in Central Railway, coming under Central Railway. The train is a Mumbai Mail, my lord. Now, my lord, after operating for a few days, the petitioner faced with some operational inconveniences. Inconveniences in the nature is this: petitioner usually transports perishable items along with life-saving drugs. I have indicated in my petition and also in the representations. And these are temperature controlled life-saving drugs. It needs to be refrigerated in a special device, which I provide with to the railways, and they keep it inside the parcel van to be transported to Shalimar on a particular time, and also from Shalimar to CSTM also back. Now, due to late running on arrival of trains at both the ends, and Shalimar and Central Railway, my lord, I represented before the authority that as the goods are perishable, some are the electronic items, majority are of the LSD life-saving drugs. So these needs to be loaded and unloaded at a particular time, which the railways provide me as per the agreement. It is not that I dictate the timetable, it is their timetable which I need to follow. And as per their placement, which is a guaranteed placement as per the agreement, I will take your lordship to that paragraph. They used to give us the parcel vans. But now, due to late running of trains at both the ends for 10 to 15 hours at each end, my lord, my perishable items are getting damaged. LSD, life-saving drugs, I could not provide it to the nursing homes and other dispensaries. Now, these problems continued for a considerable period of time, my lord. Thereafter, I made a representation. Lordship, prior to that, I will take your lordship to that paragraph, to that clause in the e-auction, in the agreement, which says, my lord, kindly turn to page 101 for once.
Yes.
Lordship, clause 11, placement and withdrawal of rakes on and from platform. Lordship has found at page 101. It states that at all train originating stations,
all efforts should be made to place the empty rake of trains at least half an hour before the scheduled departure of the train. However, in late placement of rake, the contractor shall be required to complete the loading operation within the available time and by giving sufficient time to the railway staff for sealing of SL. Now, my lord, either they have to place the rakes on time, or if they could not place the rakes on time, at least some time may be provided so that I can unload 23 tons cargo and load 23 tons cargo. Now, my lord, because of the late running of the train, they are not giving me guaranteed supply. Because if the train arrives at, I'm giving for an example, if the train is scheduled to arrive at Shalimar at 8 AM, if it arrives at 2:30 PM or 6 PM on that day, so because of the passenger constraints, the place, I usually not been favored with the parcel vans. Though under the agreement, I used to make them payment every day for availing the space. Now, this problem is has been acknowledged. This problem has been acknowledged by the railways. My lord, I will take your lordship to page 113 of the writ petition. What I say, they have admitted to some extent. My lord, this is of letter of 11th of May 2023. Lordship has got, my lord.
Yes, yes.
May I read, my lord, what is stated therein? In reference to the above subject, it is to be intimated that this division has leased out the parcel van LVBH by train number such and such to Moonline Express Cargo, that is a petitioner, private limited, for a period of 2 years with a contract value of such and such amount, rupees 24 crore 42 lakh 76,859 only. Now the concerned leaseholder, wide under their letter dated 10th of May 2023, has put forth their grievance, which is self-explanatory, and the same is briefed herewith. Lordship, this is the interdepartmental letter, which has been also forwarded to me. As per the concerned leaseholder, the train is usually running late by 8 to 10 hours in both directions, along with further delay by 8 to 10 hours during the handling the VP at Shalimar, which leads to overall 24 hours delay, resulting to deterioration of perishable consignments. Hence, it is hereby requested, Lordship, the request is being made by the assistant commercial manager to the senior DCM, the operating head. Hence, it is hereby requested to look into the matter. If any such delay has occurred due to operational reasons and within divisional control, then the same may be tried to resolve at the earliest, as well as request for early placement of parcel van at Shalimar for unloading may be considered. In addition to that, if any grievance pertains to operational constraints find in their letter by the above, then same may also be considered to be resolved. Lordship, this is this problem that they have acknowledged. Now, my lord, I will place some relevant clauses in the policy, which says that, my lord, in case railways fail to place the rakes on time, then what is required to be done? That is at page 82, my lord. Page 82 of the writ petition, my lord. It is clause 23.1 of the freight marketing circular number 11 of 2022.
Yes.
May I read, my lord? 23.1. In case of non-availability of assets, example, non-availability of space in SLR or parcel van for loading, to be utilized by the contractor due to unforeseen circumstances or administrative reasons on the part of the railways, the lump sum freight, rent, license fees already paid by the contractor will be adjusted against subsequent payments if it is possible to do so. However, if it is not possible to adjust the refundable amount against the subsequent payments, the lump sum freight, rent, license fees already paid by the contractor may be refunded. Now, the situation is like this, my lord. For availing tomorrow's parcel van, I need to pay today. It goes like this for the next 2 years. But what is happening actually is this: I am making on paying day after day, but placements are not being made on time. Sometimes even the loaded parcel vans are being detached from the train because of the late arrival of the train. So this continued. So I approached before this honorable court, lordship, for a redressal of this grievance, because I cannot sustain recurrent losses, because I pay them. It is my statutory obligation under the contract to make payment the railways, which I assured, and I didn't faltered. I only requested them to address these issues in proper person.
Once it's been acknowledged and
My
accepted.
accepted, but now, my lord, they have not stated anywhere. I don't know what instruction my learned friend has today.
May letter, I find.
11th May letter, my lord. Thereafter, I on 18th of May, my lord, under compelling circumstances, I wrote one letter. I temporarily suspended the operation.
One
requesting-
instruction I have.
Just a minute.
received.
আমি শেষ করে নি দাদা। আমি শেষ-
One instruction I have received, my lord. I have handed over to.
Please, Lordship, kindly take my letter first, which on 18th of May,
Yes.
which I have written. Lordship, Lordship, may I read? This is the letter which has come after filing of this writ application or from my end. Now, this has reference to our advocate's letter dated. Lordship, kindly see the issues which are related to the Southeastern Railway. The train are running late daily by 10 to 15 hours. After arrival at Howrah, the placement of VPU for unloading is indefinitely delayed. Placement of VPU for loading does not have any fixed time, and VPU is placed at any time, and we end up paying the demurrage charges. So these are the issues, my lord, and I have notified them that the issue till it is resolved, it is not possible for me to operate, my lord. I have temporarily suspended without prejudice. Now the thing is this, my lord, I only want from my learned friend an assistance, and let them tell me from when they will going to resolve this issue. And till such resolve is, till the problem is mitigated, my lord, they should not terminate my lease contract. Because if under the lease agreement, my lord, under the policy, if I do not pay consecutively for 3 days, they have a power to forfeit my security deposit and to terminate my agreement. So under the policy, man, as because I am grateful to my learned friend, because he has assured me on the previous occasion that his client will not going to take any coercive measures. So I am protected to that extent. But only I want an assurance from my learned friend that from when the problem will be mitigated and when I can resume my operation.
Let us hear this.
Your lordship kindly see, my lord, middle portion of the instruction.
Have you given a copy to Mr. Rao?
আপনি পড়ে নিন তারপর আমাদের
না, না,
আচ্ছা, আচ্ছা।
আমাকেই পাঠিয়েছে।
ও আচ্ছা, ঠিক আছে।
আমাকে অ্যাড্রেস করে একটা পাঠিয়েছে। He has stopped, my lord, loading and unloading. He has stopped loading, my lord. The petitioner has, your lordship kindly see the middle portion.
দেখি তো কি বলে।
Yes, but don't you think this is contrary to your earlier letter? Issued on 11th
One
May
repres-
2023?
My lord, one representation is pending before the authority of your of the writ petitioner. That is, your lordship kindly direct, that is to dispose of by the authority within a specific period.
You have admitted the entire fact in your letter issued on, please come page 113. And
Yes, yes, I have seen that. I have seen.
So you have admitted the grievance of the petitioner
Yes,
there.
this instruction they have sent me, my lord, yesterday.
This is meaningless.
Absolutely non-application of mind, my lord. Absolutely non-application of mind. Contrary stands have been taken.
The same divisional commercial manager has written to this, written this letter just a few days back.
Yes,
So how do you explain?
my lord, your lordship kindly consider direct the authority to consider his representation.
Which representation?
Representation, lordship, they have taken note of, but they have not resolved this issue.
Where is the representation?
The representation is at page 110. I have categorically stated, my lord. And if my learned friend, let him say.
Issue can be resolved only with proper timing of the train, isn't it? Nothing else.
Proper timing of the train, but they are not saying so. They are not, at least I need an assurance from them, at least whether they will eager to resolve this issue. Because I will make an payment, but they will not.
They are eager.
Eager. In that
Then,
case, my lord,
It's difficult to set a time frame for this.
no, my lord, I
must take a
absolutely, I
practical
bow down
approach
to
to
your
this.
lordship's observation. These are technical
We must have
matters.
a practical approach. to
Now,
this.
practical approach, my lord, as per my suggestion, subject to lordship's kind convenience, my lord. If they have acknowledged this problem, so let them resolve this problem and let them take me into confidence while resolving it. And till such problem is being mitigated from their end, they should not coerce me to make the payment. Because at present, it is under suspension with prior notice to them, which I have issued. I have appended that. In the present representation also, I have stated in page 112, my lord, kindly come. What I have stated. I am before your lordship with a clean hand, my lord. Kindly see. Page 112, the last paragraph. In the premises, if operational inconveniences as deliberated above is not addressed in coming 7 days from date of receipt of this letter, you understand we'll have no option but to suspend the leasement operation temporarily. Forthwith, and the instant letter in that case may be treated as a prior notice as per relevant clause of the policy. My lord, I have intimated them. Let them resolve this issue, come back to me and tell me when to resume. And they should at least be restricted from asking me the freight charges till the problem is resolved, my lord. This much I have said. And this particular issue, my lord, has already been adjudicated, my lord, by another coordinate bench. My lord, may I place that order? It will be, I think, some relevancy here in this. Ekটু জজ সাহেবকে দিন না। হ্যাঁ, আগের দিন দেখিয়েছিলাম জজ সাহেব।
বলেছিলেন যে relevant নয়।
Only the ratio, my lord. I am not going to trouble your lordship with the entire order. My lord, if your lordship kindly come to 3 pages. Pagination korani. 1, 2, 3, 4, 5. My lord, the 5 internal page 5, my lord. My lord, I'm seeking apology, my lord. It's not been paginated, but only starts with in the present case, in the last paragraph. Internal page 5. Lordship, I'm seeking apology.
Yes.
In the present case, unfortunately, the railway authorities have not taken any step towards resolving the issues raised by the petitioner in respect of unavailability of sufficient time. There, the problem was loading time, my lord. Here, the problem is placement of rakes. But the inconveniences is both there and here. Following other operation, it is incumbent upon the railway authorities to resolve the dispute immediately and to treat the period from the date when the petitioner raised the objection, that is on May 29. 2022 till the date of resolution of the dispute dies non. Dies non means if they do not resolve this issue, but subsequently they fix it up and problem is sorted out, then that period they should not charge me. Now, my lord, insofar as the losses allegedly suffered by the railways is concerned, it is none but the railway authorities who are to be blamed for such losses, if any, since having acknowledged the problem, here also they have acknowledged, raised by the petitioner by way of a written communication, no action for resolution of the same was taken at the end of the railways. Same here. In such view of the matter, WPA number is allowed, thereby setting aside the communication dated such and such, whereby the petitioner was directed to start leasing operation as early as possible. Otherwise, penal action would be initiated against the petitioner. The respondent number 6 shall decide on the objections raised by the petitioner in the petitioner's communication in respect of loading and unloading of problem and ancillary operation problem as expeditiously as possible, possibly within 4 weeks from date. Immediately upon such resolution, which will be taken in accordance with the law, and upon giving an opportunity of hearing to the petitioner, the respondent number 6 shall intimate the outcome of the same as well as the date of resumption of operation, giving a reasonable period for us to resume the. This was the order, my lord. Only there the problem was 3 hours of sufficient time was not being provided. Here only the placement of rakes are not being made because there was delay. So, my lord, till such problem is mitigated, my lord, I should not be coerced to pay the freight charges. And they let them fix the problem, intimate us, we will resume it.
Yes.
I have to take instruction on that point.
What instruction? এটা তো
আমি কি করে problem solve করবে?
Please see to it that no courses steps are taken.
Yes, Lordship, let it be a written one, my lord.
Yes.
Let it be a written one, because my lord, it is very difficult.
That was not in the earlier order, my lord, but I was communicated to them.
Absolutely. So what, why?
They
why
didn't
are
take
you
any
insisting on
coercive.
it?
Only one line, lord, my lord, for 2 days. For 2 days.
Next week, your lordship
Next
can
week.
take it up.
Let him come back with instructions. There'll be no,
No, see, till that time. Because my lord, I have shown, this is a court of equity, my lord. I have done
bar, and it is being worked out. You're not facing any difficulty at all.
difficulty is this, my lord, because there is no written order, the authorities are saying that they will not going to follow it up, and they will not going to abide it until and unless there is a written order from this honorable court. Only on the basis of my learned friend's assurance, my lord, till date they have not terminated. But if they terminate it, suppose they do not listen to him and terminate it, the entire scenario changes, the color of the writ petition changes.
He's representing the same authority.
Is representing both the railways, central, south, both.
That is what he said on the earlier date.
Yes, yes.
Yes. So
Then
the
in that,
authority will not listen to his instructions.
then only.
Come back, come back. It is contended on behalf of the petitioner that the petitioner entered into a contract with the respondent authorities for leasing of 24-ton for leasing of parcel van of carrying capacity of 24 tons in connection with train number 12810. However, what is the CSTM?
Chhatrapati Shivaji Terminal.
The terminal.
That is Victoria Terminus, my
From
lord, it was
Howrah
earlier.
to CSTM for a period of 2 years. And was asked to commence operation from 15th April 2023. Stop. The petitioner deals with consignments of consignments including life-saving drugs and vaccines, which are perishable in nature. Stop. Due to delay in running of the train for over 24 hours, your loading, unloading time has also been restricted, isn't it?
Yes, my lord, within the restricted period, I have to load, but beyond time, if it comes after 24 hours, then the entire day goes, the entire freight goes, and they are not refunding the freight, they are forfeiting it. And I am not being able to carry the consignments.
The petitioner has been facing operational inconveniences since the consignment is exposed to the risk of contamination.
Yes, my lord, definitely. It has a time, temperature control. It has a certain time period beyond which it gets damaged. It becomes useless.
And the loading/unloading time has been substantially curtailed. Stop. Pursuant to a letter issued by the petitioner to the authority in this regard, comma, the Assistant Commercial Manager, Kharagpur, by a letter issued on 11th May 2023 to the Senior DOM within bracket CO slash Kharagpur, comma, Southeastern Railway, comma, requested the latter, LATTER, to look into the matter and try to resolve the same at the earliest. Stop. The petitioner complains that despite acknowledging the difficulty/inconvenience faced by the petitioner, comma, no step has been taken by the authority for redressal of the same. Stop. Finding no other alternative, comma, the petitioner. Where is your representation?
Representation is at page
Stopping
110.
operation.
It is of 10th of May 2023.
Comma, by a letter dated 10th May 2023. No, pursuant to this, the
They
communication
have
was-
acknowledged it, and thereafter another representation, my lord, I have handed over in course of hearing, that is of 18th of May 2023, where I have stated that they have not sorted out, even though I have assured us.
Last sentence. By a letter dated 18th May 2023. 18th May 2023. Intimated the authority of temporary suspension of operation with effect from the said date till the issue is resolved by the authority. Learned counsel for the petitioner submits that the petitioner may be permitted to temporarily suspend the operation till the issue is resolved by the authority, and the authority may be restrained from taking any coercive measure against the petitioner for such temporary suspension. Paragraph. Learned counsel for the respondents seeks to take, these are the issues on which you need to take instructions. Because you have acknowledged the difficulty, the inconvenience. Please take specific instructions as to how you can solve the issue. How you can resolve the issue. Because
See,
again,
if they can resolve it within this week, Lordship, I undertake, Lordship, record my undertaking. If they resolve it within this week in proper perspective, my lord, I will resume my operation. But if they do not, my lord, give me the parcel ban, but I pay. Lordship, I have been invited for the dinner. I have not been served with the dinner. This is the thing.
Learned counsel for the seeks to take instructions in this regard. Paragraph. Let the matter appear under the same heading on 23rd June.
23rd June, my lord, I think, my lord, in that case, my lord, as because 23rd June, my learned friend has assured before this bench that they will not going to take any coercive measure. Lordship, kindly record to that extent.
Need some time to take instructions.
If they need at least 3 weeks time, Lordship, kindly no
Will you
coercive.
come back on 16th June? Will it be possible?
On 23rd. Then in that case, my lord, 23rd June, my lord, 20 days delay.
So we can rely upon your undertaking?
Yes, yes.
I'm not recording anything.
Yes, yes, Lordship. Already I will communicate.
Please confident, sir. Why are you worried?
I'll
Because
communicate.
I only worry, my lord, this thing, my lord. Already I've invested 60 lakhs as security deposit. And in the policy, it is said that if I do not pay for 3 consecutive days, then
Which is over.
which is over. The policy is staring at my face.
And this is, I have also highlighted here, Lordship, kindly see.
The matter is pending, Mr. Roy. Let him come back.
I understand, my lord. If they take any coercive measure, the entire picture changes of this writ petition, then I have to withdraw it. I have to file afresh. That should not be done. This much I expect.
On
That
that
is
point,
not the bar.
Yes, yes.
Yes, next matter.
Grateful, my lord.
Number 36.
Who is appearing for the respondents? Mr. Sen, you're appearing in this matter?
একদম ছোট করে বলবে, অত কথা বলবে।
Please take the microphone, Mr. Khan. Please take the microphone.
Well, kindly see the page number 21.
Yes.
We are holding the permanent stage case permit on the notified route number 24, 24A, 24B, 24B by 1. This is the notified route and also note.
You're reading page 21.
Yes, 21, page note 21. On serial number 7,
Yes,
these are the route.
the routes, yes.
The 4 routes, these are the combined route. We are flying the vehicle on the said routes on
Yes.
rotational basis. Now, my lords, now can you see the page number 33. This is the notification. This notification was issued in the year 2003. Under section 71(3), number of permit has been fixed. And my lord, relevant portions of this route, page number 35, serial number 37. Notification 33.
Yes,
And also, my lord, the relevant portion, page number 35, serial number 37, route number 24, and a combined route, 4 combined route. Serial number 37,
yes,
38, 39, 40 combined route. And all offset to Badaghat is the original route, 24. 24A, my lord, Pantola to Badaghat. 24B, Kosba gas terminal to Moidan. And 24B by 1, Dhankora to Howrah. My lord, so far the other 3 route is concerned. 24, 24, 20. My lord, B by 1, we have no complaint. My lord, so far the Dhankora to Howrah, this route was 24B. Well, we made an application for extension of the route, page number 24.
page number
24, page number 24.
24.
24, for not for extension, the curtailment of the route. The original route is page number 20, sorry, page number 37. Page number 37. Page number 37.
Yes,
Made an application for curtailment of the route. Only 3 kilometers. And that after curtail route will be after 2. I am reading my lord, but just first paragraph. Wish to inform you that we are 24B bus owners flying the buses from Howrah station to Borokol during last 12 years. Please note, Kolkata Traffic Police has shifted our route number 24B from Dhankora to Borokol approximately 12 years ago. Well, we made an application. Now, my lord, after this application, we that sorry, what we get to now. Page number 39. Can you see the page number 39? Again, my lord, we have another representation on the same issue, the prayer for curtailment on 19 July 2022. On the basis of that application, now can you see the page number 41? Secretary General Taswatri Kolkata region requested the Deputy Commissioner of Police, because this route mal cover under the jurisdiction of the Kolkata Police Commissioner. So, my lord, this requested, my lord, the Secretary at the Kolkata region requested Deputy Commissioner of Police to opine
yes,
the matter from the traffic point of view, whether my curtailment will be permissible or not. Now, can you see the page number 42, Annex P5.
42.
42.
Yes.
Now, the Deputy Commissioner of Police, after receiving that prayer for the notice of the.
This is a no objection.
Yes, NOC was issued. Not only this, my lord, requested also, advice also, my lord, authority suggested the regional transport authority, if the my lord route is curtailment, there is no problem. There will not be effect on the my lord, the daily commuters because sufficient my lord or is flying on the vehicle. Not only this, my lord. So far the last my lord termini point, there is no sufficient space to accommodate vehicle. For this reason, traffic department also suggested for curtailment of the road. After receiving this my lord NOC, matter was placed before the RT board meeting. Page number 43.
Yes.
Relevant portion, next page, page number 44, but agenda number 11, top.
Yes.
24 beats indicate that was placed. Also, here also recorded the existing route and also proposed route. And Deputy Commissioner of Traffic Department, Lal Bazar, issued the NOC that also recorded. Now the kindly see the decision to take decision accordingly. The RT board discussed the matter and decided to take decision after more scrutiny, as there is a specific objection against the buses plying in the cattle route. Objection. Who is the objection? Now we have identified that the objection was raised by the some operator of route number 28. Because they are also operating on the sales assembly, major portion of the route of the covers. Has got it?
Yes, yes. So no decision has been taken?
No decision, final decision is not taken because objection is there. But I have annexed also an objection of the existing operators to IMN party.
Yes, yes.
Because they have raised the objection. So kindly date them direct because they objection that we are flying, we are the before curtailment, we are already flying on the cattle route. They are the objection. These are another issue. For this reason, they have another issue. Another representative has been issued on route number 28 operators. I have met the party this proceeding matter is fixed tomorrow also. Here in this case, my lord, my application for external curtailment route is pending. And relying the decision, suggestion of the traffic department, decision was taken only in view objection of the objections that are pending. So kindly direct the authority to take a final decision for cattle on the issue of curtailment.
Yes.
Let the direction be given, my lord, that a decision, a final, let them take a decision, a final call in the matter. After, my lord, considering all those, my lord, the objections from the DC traffic, and at the same time, my lord, the objection that put
I
forward.
agree.
I
agree.
The objection that put forward by the private operators. So
We are the operators of route number 20.
Yes, they will deal with all the objections also.
Yes, yes, madam.
Yes.
For this, I have met party there.
Kindly
allow a chance.
And my lord, in the meantime, my lord, kindly, my lord, because in the same resolution board meeting, it was also, my lord, if you will kindly have a look, page number 45. My lord, at the middle portion, the route committee of route number 24P and 28 appear before the RTA board. They duly heard. No, they were, my lord, not here, sorry. They have been asked not to, my lord, ply their vehicle on the proposed cartel route. Kind of the RTA board discussed the matter, decided to give a time opportunity of 10 days to the route committee of route number 24B to submit an affidavit with declaration of compliance to the original route alignment. Until and unless a final decision is taken with regard to their prayer for curtailment, or because this is not a prayer for simplicity or curtailment and deviation. The route alignment is also would be changed
automatically. Yes.
So finally, before taking any final decision, let them fly their vehicle according to their permit condition.
Unless curtailment is allowed, there is no scope for.
But they were doing that.
Why do it, my lord? Traffic department, because
no,
in the city of Kolkata,
All vehicles are flying subject to traffic
Traffic
restriction.
has only
One way,
recommended.
one way, so my traffic department,
There, my lord.
because they have
They have
sufficient
only
say to
stated in the
accommodate, to
petition.
avoid the
No, no.
accident. They.
Recommendation, traffic
We have
has
allowed to
recommended.
apply on.
They have not allowed.
I think this is the law. This is the law. We cannot violate the law. because-
Traffic has not allowed, traffic
Yes.
has recommended.
Yeah. They recommended.
The board has to allow.
Also, they are suggested to apply the vehicle from this. Not
They
necessary.
have the authority to give any suggestion.
Suggestion in writing,
No, no.
but in the field,
Petition
they
is paper.
requested to apply from
Plain
this
is
place because there is no sufficient space.
So
There is
please continue in terms of the original permit till the final decision is
so kind
taken.
of violation, 40 days can be fixed. 40
6 weeks, 6 weeks.
6 weeks.
Board meeting, 6 weeks.
And on the said board meeting, my lord, we the operators of group number 28 being the objective, my lord, we will give the
Objections will be heard.
yes, yes.
Yes, why, I'm just, I'm
Also, the objection is annexed.
now
to
the
repetition,
objector,
my lord.
I'm
May I tell
Why-
one thing? Lord?
why I'm saying-
Since the, my lord, it has to be decided or the decision has to be taken within a particular, my lord, the period.
after here.
And if it is, my lord, within 6 weeks, they, my lord, so far the, my lord, the personal hearing of the objector as well as, my lord, the permit holder, they are 24B. My lord, the notice be given to their respective lawyer.
Now, what
So
I'm saying,
kindly.
what I'm saying. Now, object number route number 28. Their route, my lord, is Howrah to Shialda. They
No,
are
that-
operating the vehicle up to Beliaghata in violation route condition.
What
Wrong
is
to us
that
not
is
get
not in the
benefit out of it.
Lordship, kindly see this.
That's not the issue here.
Not the issue in the
the
petition.
issue?
Not
And there is a
relevant.
specific direction from the police
Again.
authority.
Yeah, in my case also, there is a direction of police
There is-
authority.
Heard learned counsel.
You have not annexed anything.
The petitioners
No, তোমার client চালাক-
are stage carriage permit
আমি
holders
বললাম, তোমার করে চলবে না, আবার করে।
in the route 24, comma 24
May I-
capital A, comma 24 capital A/1
একটু করে নেবো, একটু আমি settle হয়ে গেছি।
and 24B.
বলবে, তাহলে আমি বলে যাবো। সেট উল্টো করে নিচ্ছি, নামটা রেকর্ড করছি। সেট হয়ে গেছে, উল্টো করে নিচ্ছি। নেক্সট ম্যাটার। দুজনের নামটা দিয়ে দেন। তারপরেরটা 37 টা।
Stop. On account of congestion in the route 24B, comma, the petitioners comma, by an application filed before the Additional Director Transport Directorate, comma, PVD, comma, Kolkata Zone on 18th July 2022. Requested curtailment of the route from Howrah Station to Borofkol. This route needs to be curtailed, isn't it?
No, my lord.
No, Malo, our route, Malo, the,
They are asking for curtailment from Borofkol to Dhangorpar, the end portion of the route. And they want to fly from Howrah Station to
Page
Borofkol.
37 is your,
page number 24, the route number.
no, your application for curtailment is page 37.
Our application by law.
That is page 37.
But, you know, but it will be better, can you see?
Curtailment of route from, where is it stated?
No statement is there.
Paragraph 4 says curtailment of route Howrah Station to Borofkol via Munshi Bazar.
Now can you see the another representation? Our route is Dhangorpar to Howrah Station, 10 kilometers. And
That is the present route.
and the proposed curtailment page number, middle portion on page 39. Proposed curtailment 24 Howrah Station to Borofkol SUVRA running total 70 kilometers. That means my lord, route to be done from Gorakhpur to Dharamkot.
So the curtailment is Howrah station to Borofkol.
No, curtailment from the Gorakhpur to Dharamkot. And after curtailment, it will be Howrah station to Borofkol.
Wrong prayer was made, my lord. Actually, the prayer is
It is not easy, it is
Yes.
contradictory. Proposed curtailment is Howrah station to Borofkol, page 39. Page 37 is otherwise. Page 37 says, yes, Howrah station to
Howrah
Borofkol.
station to Borofkol, via Munshi Bazaar.
That is the curtailment you are asking for.
That was less than the decided by the authority. Gorakhpur to Dharamkot. That has been decided.
Your prayer is Howrah station to Borofkol.
Issue of trade model is traffic department, traffic suggested the Gorakhpur to Dharamkot. Can you see the plate number 42?
Page 41, same thing, route alignment, Howrah station to Borofkol.
No, route alignment, Howrah to Dharamkot.
Please come to page 41.
Yes, no.
Everywhere it is Howrah station to Borofkol. No, no, please, why notification? Come to your application. What is your prayer? The authority will not go beyond your prayer. Your prayer is curtailment from Howrah station to Borofkol. Please come to all the documents. Otherwise, you have to make a fresh prayer. Yes. All the curtailment is from Howrah to Howrah station to Borofkol. In so
Decision has been taken. That will be clear. Decision is clear. The decision has been taken by the state. The page number 24, 44. Page of 44.
Page 42 says no objection for curtailment of route as proposed. Your proposal is Howrah station to Borofkol. How do you go beyond that?
The English book has the page number 44. These are resolutions, the alignments.
Howrah station to Borofkol.
Howrah station to Gorakhpur with line.
Yes.
7 kilometers. What is the route of 10 kilometers up to Gorakhpur?
The curtailment.
From our system to Gorakhpur 7 kilometers. That is the resolution.
Prayer is something different. Resolution is totally different, my lord.
Yes.
The prayer is different, my lord. And yes, my lord.
Prayer is absolutely different.
Yes.
Your prayers in the petitions. Prayer of the petition, not the writ petition.
That is
Prayer
at
in the
page
writ
37.
representations.
Representation at 37 and 41.
Prayers in your prayers of your representations. So cannot be considered.
Already consider, but all the objections.
The court will not go into this.
The respondent's objections.
Yes, but so because I have to record that.
How can you because
I have to record that it is a wrong representation. It is from Howrah station to Borofkol. That is your representation. Very well, you can let him make a fresh representation.
Within 7 days. And these shall be taken within 7 days, 6 months.
কি বললাম বলতে?
সেট কি আবার ভাই হবে মাল হবে এই কিছু
এটা কেটে দিন এই জায়গাটা on account of congestion of the রাখুন. The petitioners seek liberty to submit a comprehensive representation before the concerned authority for curtailment of the existing route and for plying their vehicles Page 44 is the route. Howrah station to Borofkol via Borobajar.
Yes, my lord.
That is the route you are asking for.
Howrah station to Dhangarpar, and this is the frame of code. Existing route, Howrah station to Dhangarpar.
No, the proposed route is
Howrah station to Borofkol.
কি বলুন?
We supply. But
Yes, yes.
supply up to Howrah station to Borofkol, and Cuttleman will be from Borofkol to Dhangarpar. 3 kilometer will come.
Borofkol to Dhangorpara is nowhere in the entire writ petition.
So the clear from Dhangarpar, the clear. Well, kindly see the permit, kindly, page number 21. Our route is already our 24B. Yeah, 24B. These are just our part to Howrah station. As per airline notification, not as per notification, the route has been mentioned. Our part to Howrah station, that is 10 kilometers. And my lord, our intention for Cuttleman from Borofkol to Dhangarpar 3 kilometers. After Cuttleman, route will be Howrah station to
Borofkol, but nowhere in the representation they have stated anything. My lord.
There are clarified also.
And the NOC was given by the police authority, my lord, in terms of their proposal.
Existing route is Howrah station to Dhangorpara.
Yes, my lord.
That is the existing route.
Yes.
And your proposed route is Howrah station to Borofkol.
Yes.
Yes.
Supply up to Borofkol. After
Yes, that is, yes, কি বললাম?
Borofkol to Dhangarpar.
Yes, Borofkol to Dhangorpara, you do not want to ply, isn't it?
Yes, yes, my lord. Yes.
So your representation is correct. Why? What are you saying, Mr. Khan?
Beginning I have.
বলুন প্রথমটা আগেরটা বলুন ঠিকই ছিল requesting curtailment of route from Borofkol to Dhangorpara. From Borofkol to Dhangorpara, so that to Dhangorpara, the language is wrong here.
Yes, my lord.
Language is wrong. In order to enable the petitioners to ply their respective vehicles from Howrah station to Borofkol. That is what you want. Stop. Pursuant to the said application, representation, pursuant to the said application, the said application, comma, opinion of the Deputy Commissioner of Police, comma, Traffic Department was sought by the Secretary Regional Transport Authority, comma, Kolkata Region, with a letter issued on 22nd July 2022. In reply to which the Deputy Commissioner of Police, comma, with a letter issued on 27th July 2022. 27 আগেটা 22 ছিল। Issued a no objection to the proposed curtailment of route. Stop. The Regional Transport Authority, in its board meeting held on 30th August 2022, afforded opportunity of hearing to the petitioners as well as other interested persons, and objections were filed by other operators, including the private respondents hearing. Stop. The requests made by the petitioners have not been finally decided by the board, B capital, despite no objection accorded by the police. The petitioners pray for a direction upon the concerned authority to dispose of the application made by the petitioners by a reasoned order at the earliest. Paragraph. It is submitted on behalf of the state respondents. Second respondent. That the second respondent be directed to consider the application filed by the petitioner upon taking into account the submission made on behalf of the petitioners as well as objections filed by other operators in this connection. Paragraph. In view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the application filed by the petitioners for curtailment of route within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, and upon taking into consideration the submissions made by each of the interested persons, as well as objections filed by the other operators, including the private respondents. Paragraph. On prayer of the respondents, liberty is granted to issue notice of hearing upon the learned counsels representing the parties before the board. Paragraph. The decision taken by the authority shall be communicated to the petitioners within a week thereof. Disposed of.
Kindly note one thing, my lord. They are not only pray for curtailment. They are already prayed for deviation of the route. Lordship, kindly record that.
The authority will decide.
That is my submission, Lordship. Kindly add
Curtailment
one.
will include ওটা
Curtailment does not include deviation.
stated আগে একটা করুন, it is submitted on behalf of the private respondents that the petitioners have prayed for deviation of their existing route in addition to curtailment, which shall prejudicially affect the other operators
Yes.
in the same route.
Deeply.
In the route, same, in the route. তারপরে stated টা।
Deeply.
Yes, next.
37.
What the state is.
Petitioner, Mr. Khan.
Here in this case, whether the disputes of the timetable in between the petitioner and private respondent.
Who is appearing for the private respondent?
I have already submitted the submission ready. Normally here in this case, my lord, during the pendency of the writ petition, my lord, the secretary at here, informed to all the parties to settle the issue of the timetable. All of that timetable was settled. I have instructed by my client on the basis of that settlement.
So your grievance has been redressed. Affidavit of service, none appears for the private respondent despite service. Paragraph, it is submitted on behalf of the petitioner that during pendency of the writ petition, the grievance of the petitioner has been redressed by an amicable settlement arrived at between the parties. Between the petitioner and the private respondent, parties will state issues. Paragraph, in view of the above, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of. Urgent certified website copy. This is a copy, Mr. Khan?
Number 38.
Transport Department, Government of East Bengal, by notification dated, see the page number 22. Page number 22. A route was completed. Section 68, paragraph of this notification. Read with section 71(3) of the Motor Vehicles Act. Under section 60 days, route has been completed. And under section 71(3), number of permit was fixed. Following the number of permit, so many routes have been fixed. One of the route numbers, serial number 1, Kolkata station to Newtown, Rajar. And followed route alignment, Ayas Ambazar, Hanna, Uttaranga, PNB, Laboni, Vikas Bhavan, Urmamoi, and Salt Lake Sector 5. And please tank total 20. Nature of service, limited stock service, number of seats shall be on HP. Nature of service only. So on the basis of that notification, permit was issued on the route number A1. Go to the station to Newtown. That's the route number 24. That permit was issued on the route number K1, Uttar State to UP World City, Newtown, Rajarhat. Now, my lord, we made an application for extension of the route, page number 39. Page number 39. Page number 39.
Yes.
Extension of route K1. Extension from Rajarhat, Newtown to Hatishala, only 3 kilometers. The existing route, my lord, 18 kilometers. And my lord, extension, we rate for extension only 3 kilometers. After extension, route will be proposed total 21 kilometers. But after receiving that application, page number 40, Secretary Regional Transport Kolkata region
48.
This group is covered by the police commissioner. That the Deputy Commissioner of Police Traffic Department, Lalbajan, and the Deputy Commissioner of Police Traffic Department, Vidhanabad. And they wrote a letter, the Deputy Commissioner of Police Lalbajan and also.
This is at page? Page?
Page number 40. 40.
Yes.
This memo was issued by the Secretary RTA addressing to the Deputy Commissioner of Police Traffic Department, Lalbajan, and Deputy Commissioner of Police Traffic Department, Vidhanabad, because the reason covered two Vidhanabad, two police commissioners, because an opinion is required from that traffic department point of view. After receiving this memo, both the commissionerate, police commissionerate, informs the authority, the secretary, that there is no objection and there is no public interest to so many. Now the matter was placed before the after receiving this memo, the opinion from the traffic point of view.
Where is the opinion?
About 41.
Where is the opinion?
In the line of annex, but that has been recorded in the resolution. Page number 41. Page number 41.
Yes.
Relevant question. Relevant question. Page number 43. Serial number 6 is the agenda. Agenda, please find enclosed for settlement. For settlement. For extension of route K1 from Secretary Regional Transport Secretary Customer Association dated 12 October 2020. Existing Kolkata Station to New Town. These are not government and the proposed route alignment also Kolkata Station to Hadisa. And traffic department views fourth paragraph, the RTA traffic department Lalbajan Kolkata proposed to find in this matter from the traffic point of view that Mission Traffic Department Lalbajan Kolkata has given no objection from traffic point of view for the extension by memo dated 30 November 2020. And so far the Vidhanabad of this is concerned, we have also proposed to find and given the objection from traffic point of view for extension of the route on 9 December 2012. Now can I take the decision? Take decision accordingly. Resolution: the RTA board fully discussed the matter and decided to take decision after getting the field inquiry report from the officials. Matter was kept pending. The finally getting the field inquiry report from the officials. After taking this decision, the regional secretary I memo dated page number 48. Page number 48. Let us see we have to subsequent field inquiry. Right? You are requested to make as one field inquiry in respect to the above mentioned subject whether any problem arise in the transport system in that area or with the subsequent questions. Submit the report to the or I don't know what is the report submitted. I think this matter pending. Now can you see the next page?
Yes.
Matter was placed in the meeting. How matter got placed? Because decision was taken on March 2023, the board meeting. What is the resolution? Now can see the page number 50. It's not my God. Video number 5.
50.
50. Next page. Serial number 5. A mass petition was received from the inhabitants of villages Atishala to Dhanmogar, Kongalia, Tenkara, Bapapur, Gatuya, Sonpura, for impression of the new station, Atishala to Artillery Unity, Tata Medical Uniform, On the sales sample, we have defined for the expense of the inside Hatisala to we give out sales sample for public interest. And here in this case, what about after this starting calling also we get the operation. Now can see the decision. Take decision resolution. We will spend 60 for market installation. Pending. Our pending expenses for public for we are not the cost efficient. Adopting the resolution of operation for Hatisala to Kolkata station. Our we are also the same. And also number of funding also to fit. They are decided to approve. And it is decided to send a proposal of hospital. This is the mission. Now I see the another sales issue. Now, this before that, my lord, we raised the objection. Page number 52. We raised the objection, strong objection on behalf of number A1 customer association against the competition. Why we have the objections? Because our existing route, my lord, goes at the station to Newtown. Our rate for instance from Newtown to Hatisala 3 kilometers. So after extension, route will be 30. So what is the law is settled by the division bench of this honorable court. If it is once completed, there is no necessary for further introduction of the new rule on the sales survey, on the existing rule, on the intermediate stages. Because this is the new rule, this is the same existing rule. Only trade for extension. There is no requirement for progress of the new rule. Keeping my application pending, this business has been considered pending. Another resolution was taken. Page number 55. Page number 55.
Yes.
This resolution was taken on 12/15/2023. About the resolution number 12, page number 56. The first petition that has been recorded earlier decision, not that has been recorded and also the decision Lal Bazar and Divan Nagar also proposed that will be recorded. Now we want to quote paragraph. The party board act, the first understanding, discuss and decided and 3/16 for public interest commission. The decision will be and this is now can you see next paragraph. Thereafter, Vishwa Mangal Bus Services applied for restraint of as when the secretary of the Department of Restraint has been requested by memo dated first last steps towards publication of formal notification for introduction of new state category. Hatisala to Kolkata station with the extent of 24 for promotion of vehicle in its total route. In article board, we discuss and consider the matter also that to ratify the earlier decision held on vehicle on this process. Now that's the resolution. After state discussion can be moved, approves the proposal for extent 24 for the same proposal decided that out of 24 total strength, 3/4 permit will serve exclusively process, and also decided that for 20% difference should be given for electric buses. From there we to the final decision. But what is the law? What is the law? Because Q1 is the modified.
And your application is still pending.
It is pending. It is the modified. was modified by the transport department under section 68, section 71(3).
So that gets saturated.
Transport is also decided how many vehicles should be used. That was decided, but they have taken the other approach. They cannot, RT has no power, RT has to carry out the decision of the transport department. Transport department will sanction, approve the proposal of the authority, therefore publishing the notification, there will be no that will be affected. They have to take the application of the petition pending. Even also after taking the decision third part, we have made the request authority what to introduce and provision for international of the existing. That decision is not taken. That application is not being considered at all. So kindly set aside this operator. Kindly set aside this resolution. After this resolution, also resolution of 12 April 2023, and to take a final decision on the basis of my earlier application as well as representation dated to April 2020.
That's all.
Legislation will be considered.
State government has been power.
Representation is already being considered, but in the meantime, a separate.
There is a silent objection.
No. A similar representation has already been allowed on the same route. And this is a notified route. So if the subsequent representation is allowed for the same route, the petitioner suffers. I think he needs to, will you take instructions and come back? This is prima facie not correct. This is not prima facie illegal. An earlier representation filed by the petitioner for the same route, extension of route, that has not been considered. A subsequent representation has been allowed on the same route.
Without considering.
And it is a notified route. If the subsequent representation is allowed, the route gets blocked. The route gets blocked and his petition cannot be allowed. Since in all probability this has to be set aside, let Mr. Dey come back with instructions. Affidavit of service.
I'm not very permitted to.
It is contended on behalf of the petitioners that the petitioners are operators of stage carriage permit in route K-1 within one from Kolkata station to Newtown Rajarhat. Stop. The petitioners submitted an application before the concerned authority for extension of the route for further 3 kilometers. Up to? Up to Hadisa. Hatishala. Up to Hatishala, HATISALA, which is pending. Stop. A subsequent representation a mass petition submitted subsequently by the inhabitants of several villages for a new route from Hatishala to Kolkata. Hatishala to Kolkata station has been allowed by the concerned authority in the board meeting, by a resolution taken in the board meeting held on 3rd March 2023. No, the decision was taken on 3rd March 2023. the petitioners are aggrieved by the said decision taken by the authority and by the authority. Stop. Paragraph, learned counsel for the respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 16 June. Next week. Next week. Not necessary. You're coming back next week. Yes, last one. Next.
Number 39. Item 39, I'm praying for not this week landed advocate's father severely and is advocating clearly substituting also.
You are for the petitioner? On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 23rd June.
Hearing item number 40. This is my application, my lord. Hearings have been completed. Lordship was pleased to fix this for hearing. There were 3 occasions when the respondent authorities had not appeared. On the last occasion, my lord was pleased to direct me to serve upon the other side, which we have.
You are appearing for the respondents?
Yes.
You are appearing?
Yes, yes.
Is the cause of action still alive?
Yes, my lord. The
2007
fact that there was a
matter.
claim still survives. There's a
The
claim.
claim survives?
This is with respect to overweight of the wagons, my lord. There's a punitive charge that has been imposed upon me.
Affidavits are complete?
Affidavits have been completed.
Only
I'm
thing is,
saying
my lord, but at the outset, let me say that the bank guarantee, they have revoked. But the bank guarantee should be revived first. Then only the claim, counterclaim, and all these things.
So we are willing to have.
The hearing,
Not today, but
not today.
It's been pending for quite some time, my lord.
2007
but
matter.
we are also suffering.
I am not on that, my lord.
That's
Even
not-
in the last recent few months, my lord, including the last occasion in March, the matter had come up for hearing several times, close to 3 times.
When do you suggest the hearing?
Next week. Any day suits your lordship. Convenient to your lordship.
So could I start? He can always come back and finish. I'll not finish today if that is
No,
what
no.
is falling from my learned friend.
And-
I'll not finish today. It's a very simple point.
I will also ask my client to be present here so that it can be resolved once for all. So partly today and
I'll just indicate, my lord. I'll just take 30 seconds.
16th June.
16 June.
I will. I was only saying this, my lord. With respect to the punitive charges that have been imposed, I am going to argue only on the point of law that today this punitive charge itself could not have been imposed because they themselves had originally weighed the goods. I'll show one judgment. I'll not take too much time.
What
I was
What
only.
next week?
But what about the bank guarantee?
Why is it necessary? I'm
That has
willing
been
to dispose of the writ application.
Yes. On 16th.
Affidavit of service. On prayer of the, you are representing all the respondents?
Yes.
On prayer of the respondents, the matter is adjourned. Let the matter appear under the same heading on 16th.
16th.
Deeply obliged.
Sleep like.
Yeah. It's all the monthly lists. 1178.
1179.
8 টা কোথায়? 8 হয়ে গেছে? Oh.
Monthly list group 7, item number 1179.
I'm for petitioner. It is WPS 7568. No, it is 7568.
7568.
I'm led by Mr. Kishore Dotto.
What about the respondents?
Respondent is supposed to file their opposition honorable judge's copy because this was not available. in the
Opposition.
record. Yes, yes.
Reconstruction.
It was no, no, reconstructed AO.
This is 1182 and 1183.
What about 1179?
7, document 79.
79.
What about 1179?
It is
That
there.
is repetition number 7568.
Yes.
80. So 7568 Aparna আছে।
But it is there. In 758, the opposition is there in the file.
So shall we start?
Yes.
Your Lordship, before that, Your Lordship, so far as these issues are concerned, Your Lordship.
Please take the microphone, madam.
Microphone. Your Lordship, the same issues, Your Lordship, Honorable Division Bench was in favor of the petitioners, Your Lordship. From that, the railways had filed an appeal, Your Lordship. Your Lordship, it has been tagged with other appeals, Your Lordship, on the similar issues, that is on the rationalization schemes, Your Lordship, and the undercharges, Your Lordship. Those are pending, still pending, Your Lordship, before the Honorable Supreme Court, Your Lordship.
For the division bench is pending?
No, Your Lordship, it has been admitted, Your Lordship, for hearing, Your Lordship, of directions for affidavits and all have been given.
And
Your
it's
Lordship.
pending before the Honorable Division
Yes, Your
Bench?
Lordship.
I don't think.
Honorable Supreme Court, Your Lordship.
Honorable Supreme
Show me
Court.
the order
Your
copy, na? Here or SLP number, please provide. me.
হ্যাঁ, আমি সেটা
So in that case, let the matters go out of list for the time being.
judgment and
No, no, just এখন দেখি জিনিসটা কি আছে।
এইটা
কবে থেকে?
It's pending before the Honorable Supreme Court, similar issue.
similar issue.
So let the Honorable Court decide first.
Pilot
বাগাদিয়া ব্রাদার্স ওটা ডিভিশন বেঞ্চের অর্ডারটাও দিয়ে দিচ্ছি এই যে
once it will be, 2015.
After 2015, they filed their appeal. There is
Your Lordship, this matter was
So whatever, this court cannot deal with it at the moment. Division, according to her submission, the division bench has decided in favor of her client.
no, Your Lordship, in their favor.
Oh, in their favor,
It's our
and my lord,
against which an SLP has been preferred.
that apart, my lord, kindly considering, my lord, here filing an SLP and pending before the Supreme Court, my lord, cannot.
Your Lordship, other, many other,
This order has been, my lord, it appears from this order sheet that SLP has been filed sometime in the 2015. But after 2015, they
That's-
filed their affidavit, my lord, there is no such whisper. And my lord, according to us,
When was the last order passed, madam?
2017. I find a 2017 order from a learned friend.
That's
When
the
all
last
delay
order?
was condoned. But this is the last, my last copy.
Why
this
don't you
is
come
not,
back?
Your Lordship, one single matter, Your Lordship. There are many appeals, Your Lordship, pending.
my lord, the point
And,
are
Your
different, my
Lordship,
lord.
the last, it was heard on, Your Lordship, the 3/3/2020. Your Lordship.
Which 2020?
2020. That's
My
from
lord,
the,
that point are different, my lord. This is the point where, my lord, two routes has been availed by the railway. They, in fact, my lord, go through the shorter route, my lord, but charge in a, my lord, something more than 100 times, my lord, the area to show, to calculate their tariff. This is a different matter, and probably the matter what my learned friend, my lord, is trying to say. This is the matter regarding which circular is applicable, 2018 circular or 14 circular. Two are different matter, my lord. Kindly allow us to check this matter
Please
and
find
come back, my lord.
Please find out. Because she says that 2020, the last order was passed.
Your lordship,
But we are with the final hearing of the writ petition.
Please check and come back because she says an order was passed in your favor by the division bench and SLP has.
No. That's in a separate matter. But I'll tell you, Lordship, what is the bone of contention in this matter? Milord, my clients, Milord, transport iron ore in railway wagons. Now, Milord, there are routes from place A to place B. Now, from place A to place B, Milord, the distance is 747 kilometers. When I apply before the railway authorities, the railway authority issues a railway receipt, which has the place of origin, the place of destination, the kilometers, I mean the distance, then rate, and multiplied by the distance multiplied by the rate is the amount of the tariff that I have to pay. Milord, I have, they have calculated as per 747 kilometers. I have paid the amount, the goods transported, and Milord reached at the destination. Thereafter, Milord, subsequently, Milord, they raise an amount, a charge, which they call as undercharge amount. Why undercharge amount? Because according to them, I should be charged for 1,169 kilometers in place of 747 kilometers. Now, how does this 1169 kilometer comes? Because they say that a rationalization scheme has been framed by the railway authorities. The rationalization scheme provides for certain alternative routes so that, Milord, the main junctions are not, Milord, cloaked. The purpose over here, the rationalization scheme over here is to avoid Cuttack. Now, Milord, our point is that you cannot apply the rationalization scheme for various reasons. Number one is that if you have transported the goods through for 747 kilometers, you cannot charge me for 1169 kilometers. Number one. Number two is, if there are two routes available, the shorter route has to be adopted because that benefits me. Number three is, the rationalization scheme was given effect to after, Milord, my goods were transported. Therefore, can you give effect to the rationalization scheme from a back date? Our point is that you cannot give it from a back date. The fourth is, which is very important, that, Milord, under the law, whatever charges the railways have or claim the railways have in regard to, Milord, transport of a property, transport of some goods or materials, they have to recover them before releasing the goods. So that is the law. You may have 100 claims against me, but once you have allowed me to take away my goods from the destination point, thereafter you cannot charge me. But these are, Milord, the four fundamental points, Milord, on which, Milord, we have grounded our writ petition, founded our writ petition. Therefore, Milord, this, in my very respectful submission, cannot have, Milord, any relation to some contempt proceedings which have been.
What was the issue before the Honorable Division Bench?
Milord, so far as the Honorable Division Bench is concerned, Milord, that was, Milord, in respect of some other things. And it may be between some other parties.
yes, some other parties,
Yes.
yes.
If it is some other party, some other on the same issue, Milord, first we need to look into the facts. Number two is, if the law has been decided one way or the other, and even if there is a stay by the Supreme Court.
There's no stay, I believe.
So if there is no stay, it doesn't matter. Even if there is a stay, the law which is decided prevails. Your lordships have decided, in Chamundi Moped's case, that if a judgment or an order is stayed by the higher court or the appeal court, the execution of that judgment may be deferred.
But so far as the law laid down, that operates till such time the order is set aside. That is the distinction between staying an order and upsetting an order. Therefore, my lord, my writ petition is on a separate issue, on a separate point.
Well, I would still like to see the subject matter in the matter before the revision bench as well as the SLPs.
No, no, stay ka to kono factor na. Stay will not prevent me from proceeding with my matter.
If it's a
Yes.
different matter altogether, then it will really not affect
Yes.
this matter. Will you please come back with the relevant
Different
documents?
parties, your lordship,
Ah.
different parties, but the issue was same, your lordship. Only thing in that case, your lordship, the money was already deducted from another account of that person.
From some other
But it's-
consignment.
It's regarding, yes, it's regarding
Oh.
the rationalization scheme.
Well, even if the point is same, in all probabilities, my lord, it was decided in favor of the petitioner
Yes.
because the railways had preferred an appeal.
Yeah, that's what the submission
I
was.
said so. It is-
That's what she said.
So
Okay,
therefore, my
what is
lord, my petition, with respect, my lord, we can come back on some other day. But the pendency of an SLP, my lord, cannot stand in the way of, my lord, proceeding with my matter. Subject to, my lord, the business of the court permitting, obviously, my lord.
In that way, shall we start the hearing today?
Yes. Kindly permit me to start, my lord, because I can't finish today.
And they can go
And-
through the
and-
order, your lordship. I'll give them the order, your lordship. The
orders?
division bench order and the Supreme Court orders. Because this is not
Do you
only
have a
one
copy
matter,
of,
your lordship. This has been tagged with several other matters, your lordship, before the Honorable Supreme Court, your lordship.
Yes, but what is the matter about before the Honorable Supreme Court?
Your
Or
lordship,
for that
so
matter,
far as I
division
know,
bench.
the Bagadia matter, your lordship. It has been tagged with some Reshmi metallic, your lordship. That I don't have, your lordship.
Do you have a copy of the order of the division bench?
Yes, your lordship, but two different.
But Rashmi Metallics is on a, my lord, different point, my lord. I am hearing in those matters.
There are.
There, my
Shall
lord,
come
Supreme-
back with all the relevant
Very
documents. Let us just go through the
Very
documents
very
before we start.
এটা আমি দিতে পারছি না।
But maybe come back next, next week or week
Next week?
thereafter. Whichever date, my lord, your lordship feels.
19th June?
My lord, 19 June, your lordship keeps this matter. If I may only make this request, whatever my learned friends want the
couple
court
of
to
days
consider, if those could be given to me in advance, I can go
Yes,
through it.
I'll give.
A couple
Your
of days
lordship,
early.
can I file the affidavit in opposition? Your lordship?
Yes,
Please
sir.
file all the relevant orders, documents so that we can just go through them once.
আচ্ছা, reply তো আমাদের জমা আছে। But only to remind your lordship, my lord, the opposition was missing from your lordship's
That's the
file,
reconstructed.
reconstruction, but our reply is on record. Okay.
Documents are on record, yes. Reconstructed affidavits in opposition. In connection with WPA numbers, they can even do to us. Submitted on behalf of the respondents are taken on record. Paragraph on prayer of the respondents, the matter is adjourned. Matters are adjourned. Let the matters appear under the same heading on 19th.
But in the supplementary list.
Yes.
কত থেকে কত? শুরুটা করতে হবে। But the next three matters are connected.
8-3.
8-3.
Till 183.
Till 1.
Opposition. This is also reconstructed? The original. Omlan. Reconstructed affidavit in opposition to court. In new answer. Affidavit.
এই এসএলপিটা দিয়ে দাও, একবারে দিয়ে দেবে সব বলছি। রাজস্বী একবারে সব দিয়ে দেবে। এসএলপির অর্ডারটা
Filed by the respondents.
দিয়ে তো বাহাতে।
Are taken on record. তাই তো? Yes, next one.
ছবিটা তো এই রাজস্বী তোমার দিচ্ছি। I'm grateful.
8-8.
Item number 1184.
My lord, in this item, I'm for the petitioner, my lord. I'm praying for not this week, my lord.
Hearing matters. Mr. Debra is appearing. On prayer of the petitioner, the matter is petitioners, the matter is adjourned. Let the matter appear under the same heading on 4th July.
Grateful, your lordship.
Uh-huh. 1185.
Yes. Petitioner? No. Who is appearing? No one. Anyone for the petitioner? None appears for the petitioner, no accommodation is, none appears for the parties. For the parties, no accommodation is sought. Dismiss for default. ওই পুরোটা দেবে না?
কোনটা দিচ্ছে এটা?
1186.
My lord, in 1186, I'm appearing for the petitioner. I'm being led by Mr. Chatterjee in this matter, my lord. He's on legs before some other court. Praying for a not today, my lord, in this matter.
Praying for?
Not today, my lord, in this matter.
On prayer of the petitioner, the matter is adjourned. Affidavits are complete.
Yes, yes.
Let the matter appear under the same heading on 30th. 30th June.
Great.
আরে কাকা তুমি দাও না এটা কোনটা দিয়েছো তো
দিচ্ছি
1187.
Lordship, appear for the petitioners. Filing a reply.
Who is appearing for the respondents? Hearing matters very difficult. Opposition has not been filed.
Probably they must be having it in their hands. Should have
Yes,
filed it.
yes, but where are they? Mr. Singhania, Ms. Ranjana Chatterjee,
No, no.
no one.
The Lordship keeps it on some other day. We'll serve the notice in town.
Please inform me. Affidavit in reply submitted on behalf of the petitioners is taken on record. Paragraph none appears for the respondents. Paragraph let the matter appear under the same heading on 4th July. Please inform them.
I will.
One 1188.
দেখেছো? So I am for the writ petition in this matter, my lord. Readings are complete, my lord. Pursuant to lordship, previous direction, lordship, I have prepared a paper book. There was a
Where is your contender?
Pranajit Ghosh appears, my lord. He was there in the previous occasion. And this matter pertains to refund of the freight, my lord. Because issue is this, that I was an erstwhile leaseholder with one Kamrup Express, my lord. I entered into an agreement with Eastern Railway, and thereafter, my lord, I have paid the freight charges accordingly on both the sides. On one occasion, my lord, there was a charge of overloading against me. Then Mr. Singh, overloading against me, my lord. Thereafter, I paid the punitive charges on protest, and I approached before this honorable court for a prayer of revayment, my lord. Roshi will kindly come to page 61. Yes, page 61, lordship, of the paper book.
Yes.
Yes, this order was passed on 26th of November 2019. Worship, here I have, the Honorable Court has said that the Mr. Royal Learned Counsel appearing for the petitioner raises a substantial doubt with regard to the correctness of the in-motion weighbridge ex Howrah. Mr. Roy submits that the parcel van in respect of which the petitioners have entered into a leasing contract with the railway respondents, more particularly the North Frontier Railway, my lord, stand corrected, my lord, it's North Frontier Railway, was incorrectly weighed at in-motion weighbridge at Howrah Station en route Dibrugarh. Mr. Roy invokes Section 79 of the Railways Act 1989, for short 1980 Act, to seek repayment of the empty parcel van, which has now returned from Dibrugarh to Howrah. Mr. Roy submits that the punitive charges leveled by the railways respondent have already been deposited with the railways, and the petitioners are entitled to contest the defective weight of the loaded wagon by the in-motion process at Howrah. Considering the fact that the manual weighment manifest of the petitioner shows that the wagon parcel van could be loaded up to 23 metric ton, and the cargo loaded by the petitioner was to the tune of 17 metric ton. The issues raised by Mr. Roy are contested by Mr. Ghosh, London Railway Council. Mr. Ghosh submits that there is no complaint regarding the payment of the said wagon by the petitioner's ex-Dibrugarh on return journey of the loaded wagon to Howrah Station. Mr. Ghosh pointed out that there is a discrepancy in payment of the cargo into the wagons as claimed by the petitioners, and such discrepancy varies from 17 metric ton to 20 metric ton. Mr. Ghosh also relies upon a purported certificate of the Controller of Legal Metrology dated 27th of July 2019, certifying that the in-motion weighbridge at Howrah Station goods yard is correctly functional. Lordship, you kindly mark this observation of this Honorable Court. This is very relevant for future references. Before commencing further on the merits of the writ petition, this court at the outset requires the following formalities to be performed by the parties. The petitioners are directed to implead the Controller of Legal Metrology as party respondent. Let a copy of the writ petition be supplied to the Controller of Legal Metrology, the added respondent. Petitioners are also permitted to implead the NFR as party respondent. Let copy of the writ petition be served upon NFR. On the next date, the railway shall submit the empty tier weight of the wagon in issue being such and such number. The empty tier weight of the wagon is to be taken in presence of the representative of the Controller of Legal Metrology and the petitioners. The other issues addressed at the bar, including the point of maintainability taken by the Railway Council, shall be considered after the above recorded formalities are completed and presented before this court on the next day. Well, this was the initial order at the interim stage, my lord. Thereafter, the Honorable Court, again, on the basis of my learned friend's request, my lord, extended the time for complying the interim order, which is appearing at page 65, the following page. So this was the order that Mr. Ghosh, Learned Counsel for the respondent Southeastern Railway, submits on written instruction that the direction of the order of this court dated November 26, 2019, connected to the empty tier weight of the wagon in issue being num such and such could not be taken, since the wagons did not arrive at Howrah Station from New Delhi on and by December 15, 2019. Accordingly, Mr. Ghosh seeks extension of 2 weeks' time to comply with the directions. In view of the exigent circumstances made out on behalf of the SER, extension of time as sought for stands granted. Let the matter next appear on such and such date. Now, thereafter, my lord, the railway, without carrying out the order, file an application in connection with the writ application against the legal metrology. Not against me, against the legal metrology, the added respondent, and that they have stated at page 79 of the paper book, my lord.
Yes.
That paragraph 18, my lord, in the railways application, that the respondent railway state that in earlier occasion, whenever the said electronics in motion weighbridge Howrah was out of order, then and there appropriate action was taken by the all concerned authorities of the railways as well as the legal metrology department for repairing of the said electronics in motion weighbridge on urgent basis. It is pertinent to mention here that the act and action of the concerned authority of the legal metrology department of the government of West Bengal is contradictory, for which the safety and security of the trains carrying railway passengers and goods are in danger, as well as the railway is also suffering huge revenue loss due to the non-payment of VPSLR at Howrah, for which the non-cooperation of legal metrology department is solely responsible. Now, my lord, initially, my learned friend on behalf of the railways on instruction placed before this court a certificate that the in-motion weighbridge at Howrah was functional. Now, giving a complete U-turn, my lord. He has made an application with a prayer upon the legal metrology that they should render necessary assistance for repairing of the said electronic in motion wave bridge, which is at page 80. That page itself, Lordship, may I read the prayer portion? The applicants therefore humbly pray that your Lordship may graciously please to direct upon the concerned authority of the added respondent number 7, that is the controller of legal metrology, weight and measures, Government of West Bengal, to take appropriate steps for repairing the said electronic in motion wave bridge at Howrah station by giving permission for opening the seals provided on console unit and junction box and or pass any other further order. So it is an admitted position that in motion wave bridge was not at all functioning. This was all along, I said at the very beginning, that because of the defect in the in motion wave bridge, the women showed more. And that is the reason, Lordship, I approached before this honorable court for payment of the empty tear and the correctness of the in motion wave bridge, which they have duly admitted in the present application, my lord. Thereafter, my lord, in order to carry out the honorable court's direction, my lord, several joint reports were filed. Lordship, I will take your Lordship to page 89 of the said paper book. Lordship, this is the joint report which has been filed by the railways.
Mr. Roy, you will take some time to make your submissions, so I want to release the other matters.
I will
It
take
will
some time.
some time. Other matters released for the day.
Others matters are released for the day.
Page 89.
Page 89. Yes. My lord, page 89 is the joint report, my lord, which has been prepared by the railways in presence of the legal metrology and the representative of the writ petitioners, my lord, to carry out the interim order, which was passed at the earlier occasion. Lordship has taken a Lordship to that order. It is stated that in reference to the above, we the undersigned here having jointly attended the Howrah goods in motion wave bridge at 12 hours to witness the tear payment of the MTVP and found that the said wave bridge is out of order. Again, my lord, since 9:53 hours and during payment of one loaded VPH of such and such lease, National Carrying Corporation, women show zero weight. The entire in motion wave bridge was defective and it is showing zero weight. In presence of ACM Howrah, such and such, the undersigned have checked all the seals and provided on console unit and junction box and found seals are properly intact condition, but digitizer inside the console unit showing zero overage. However, VP number such and such has been weighed in both direction at the said wave bridge, but no weight indication was shown by the machine. On 16th of 12/2019, payment of tear weight of VP was not done due to unavailability of the subject VP at Howrah goods yard. Further date for payment of tear weight will be fixed upon rectification of the said weight. So it is clear from the joint report which my learned friend has produced before this honorable court, and I have annexed here in the paper book. Now, my lord, the second joint report, that is at page 91, regarding this aspect.
Yes.
Yes, my lord, this is also has been prepared by the railways. That it goes on saying that we the undersigned have jointly attended subject mentioned wave bridge at 23:12 at 14 hours for rectification. Service engineer of Mrs. Digital Weighing and Mr. Gurusha has checked all the system and found console unit showing zero overrange. According to service engineer of Mrs. Digital Weighing system, permission of the inspector of legal metrology is required for opening the seals provided on junction box and console unit for checking the rectification of the said wave bridge. They say that it is out of order and legal metrology's intervention is required to correct the defect, my lord. Now, my lord, the legal metrology, my lord, thereafter wrote back to the railways, that is at page 93. It is all happening between the legal metrology and the railways, my lord. This is page 93. It has been written by the legal metrology. With reference to the above, this is to inform you that the above matter lies sub judice under Honorable High Court, Kolkata. The concurrent permission from the Honorable High Court, Kolkata is required for breaking the seal and opening of the console unit and junction box for rectification of the said in motion railway bridge. After obtaining the permission of the Honorable High Court, necessary action will be taken. So it is also an admitted position from the legal metrology department's letter, which is annexed at page 93, that the in motion wave bridge was defective still then. Now, my lord, thereafter, upon rectification, I don't know whether they have at all rectified thereafter or not. At page 109, railway, in order to comply Honorable Court's previous direction, asked the petitioner to attend the weighment process not at Howrah, but in some other weighing machine at Dankuni. That is at page 109.
Yes.
Lordship, this is page 109. It says, in pursuance to the directives passed by the Honorable High Court, Calcutta, in the subject court case by order dated 26th of November 2019 and 17th of December 2009, this office has arranged for payment of the empty VP number such and such hours at in motion wave bridge at Howrah. However, in motion wave bridge at Howrah malfunctioned and same has not been allowed to be rectified by legal metrology. The blame has been given to the legal metrology department, stating that the matter is sub judice before the Honorable High Court, Calcutta. As such, to comply the Honorable High Court's order dated 17th of December 2019, this office has arranged to undertake the payment of the MTVP at the in motion wave bridge at Dankuni station on 13th of January 2020 at 12 hours. In view of the above, you are requested to make convenient to be present at the in motion wave bridge at Dankuni station on the above mentioned date and time to witness the empty tier payment of VP number such and such, my lord. My lord, to this, my lord, we raised an objection. We raised an objection that initial direction was that the payment has to be made on the in motion wave bridge of Howrah. We alleged that it was malfunctioning. It has been admitted by the railways and also by the legal metrology. And
Who is appearing for the metrology in this matter?
Metrology, my lord, we have served the copy, but I don't know who is appearing for the metrology.
The state should appear, isn't it?
Someone should appear. Someone should appear. But we have raised vehement objection on the next page, my lord. Will come at page 110. That we have stated that we will not going to attend any such of payment at any other place except the place which has been decided by the decided by this honorable court. Our objection is specifically we have taken this objection at page 112. Though our objection starts from page 110, we have taken the objection at page 112. And in the term that Lordship has found 112, my lord.
Yes.
As decision to last paragraph, my lord. Such decision lacks substance for the following reasons, and thereafter, as decision to conduct payment is being taken beyond the prescribed time limit 2 weeks as stipulated by the honorable court, such decision to conduct payment and Dankuni is going against the unanimous decision taken at the joint report that payment will only be taken at the wave bridge situated at Howrah after its rectification. Such decision to conduct payment of Dankuni is premature when railways have already filed one application awaiting final adjudication where leave has been sought for rectification of defective wave bridge installed at Howrah. And also due to the fact that railway ought to have taken leave from the Honorable High Court before such decision could have been made only after satisfying the Honorable Court with regard to its fitness of the said wave bridge at Dankuni. We have recorded our objection. Then on the basis of our objection, my lord, railway again wrote letter to us asking us to attend the payment process at Howrah itself, which will appear at page 114. The next page.
Yes.
As such, Lordship, page 114, it says that as such, as per directives of the Honorable High Court, Calcutta, wide order date in such and such, tier weight payment of MTVP to be done on date at 14 hours in presence of representative of your petitioners. It is therefore requested to send your officials on such and such date to witness the tier payment of the subject VP in motion wave bridge Howrah for compliance of the order. My lord, thereafter, the next page is the final joint report. It is stated, my lord, now you kindly see the last two lines. The actual payment of the tier which is written over the railways is 32 tons. Now, what they have found? they have found MTVP number, last two lines, my lord. MTVP number has been weighed at electronic in motion weigh bridge and found 30.70 ton Wayman sheet enclosed. Ultimately, what we have stated that in motion weigh bridge is defective, that got substantiated. Several letters and correspondence, even applications are there. What we have stated that the MTVP is weighing less, which is causing the goods set, because if it less, my lord, then obviously we will try to give more consignments where we are not aware what is stipulated as 32 is prescribed in the and is affixed on the wagon itself, but in original it's coming at 30.70 ton. So my learned friend has to say whether 30.70 ton is the actual weight of the tear or 32 which is affixed at the train and the wagon, that is correct. So this has to be done. And now, my lord, thereafter, lordship is aware that the judgment pronounced by this Honorable High Court with regard to this malfunctioning of in motion weigh bridge and of the tear weight, if it is found, then adverse inference has to be drawn, and punitive charges which we have deposited on protest, that has to be refunded back. A batch of writ petition was decided, my lord, by this coordinate bench. May I rely on this one? And it has been affirmed by the Honorable Division Bench also. Division Bench order gulo নিয়ে আসতে হবে। May I read, my lord, from the this will settle the issue once for all, my lord. From the officer in question of the railways who was directed to appear by the order dated April 7, 2022, that is the Senior Divisional Mechanical Engineer, Southeastern Railway, Kharagpur, is personally present in court and submits on query of the court that on the communication of the Commercial Department of Southeastern Railway, the said officer had sought for a repair of the disputed payment instrument on January 24, 2022. No plausible explanation, however, has been given by the said officer for non-production of empty general coach and for sending the weigh bridge in Poddopukur, Shalimar, both which were directed by a coordinate bench wide order dated August 26, 2021 to be inspected and the condition thereof to be ascertained. Such inspection has acquired paramount importance in the matter since the dispute agitated in the writ petition centers around punitive claim of rupees such and such amount, my lord. There were 5 petitions respectively imposed on the petitioners in the respective writ petition by the railway authorities on the premises that the weight of the consignment sent by the petitioner on a particular date what was more than what was disclosed and it exceeded the permissible limit. Surprisingly, when the consignments were put in motion on March 27, 2021, July 18 and July 17, respectively, at Secunderabad, Rajkot, Ahmedabad, and Rajkot points, measurements at such points showed that the weights were within the permissible limits. However, when the consignment reached its destination at Poddopukur, Shalimar, the same were allegedly weighed again, respectively on various dates, and which purported examination revealed that the weights were beyond the permissible limit. The consignment comprised of goods which are all hard parcel, being primarily electronic goods, and there was no scope of any hygroscopic enlargement or increment in the weight of the said goods due to moisture or some other factors. As such, it is unexplainable as to what prompted the railway authorities to check the weight second time and what was the reason for such increment of weight of the consignment within 2 days, during the entirety of which period the consignments were in the custody of the railway authorities. In any event, since the weighing instruments respectively at all other points, that is Secunderabad, Rajkot, Ahmedabad points, clearly disclosed that the goods were within the permissible load, would not have been any occasion to weigh the same again at Shalimar unless there was any specific allegation leveled and or found out by the authorities. No explanation has been afforded all through, however, on such score. More importantly, the measurement of weight of carriage itself in which the consignment was carried never took place during the appalling negligence and indifference of the railway authority in not even producing the same on the date of inspection before the Controller Legal Metrology. Such apathy leads to the obvious inference that there was deliberate collusion between the railway officials in order to cover up the misdeeds which has been taking place and to hide the fact that the weighing instrument at Shalimar has all along been defective. It is shocking that on the basis of such apparently defective instrument, punitive charges were levied on the petitioners in each of the petitions, which may very well have been the usual practice of the concerned office bearers of the railway authorities against several other consignors as well. It is unimaginable as to how the machine could be sent for repair on January 24, 2022 at the instance of the railway itself, despite there no report on the condition of the weighing instrument having been prepared as on the relevant date when inspection was held by the controller legal metrology. Since the machine was admittedly defective, as evident from the effort of the railway authorities to seek repair on January 24, 2022, backward presumption has to be drawn, and it can be very well be inferred that on March 29 and respective dates, the weighing instrument was defective, as well as giving rise to the wrong recording of measurement of loads of petitioners and maybe others' consignments. In such view of the matter, due to non-production of the carriage as per the direction of this court, and due to suppression of actual conditions of the weighing instrument by sending it conveniently for repair before a report with regard to its condition was prepared, adverse inference is drawn under the Evidence Act against the railway authorities. As such, the petitioner's contentions in all the petitions that the Shalimar weighing instrument was defective at the relevant point of time and punitive charges were entirely beyond the authority of the railway authorities to be imposed are vindicated. Hence, WPA number such and such are allowed, thereby quashing the demands respectively dated such and such for punitive charges of respectively such and such of the writ petitions in respective writ petitions. Southeastern Railway shall refund the entire amount paid under duress and compulsion by the petitioners in each writ petition, in lieu of which such punitive charges, along with the forfeit charges and any other amount of money which the petitioners in each of the writ petitions might have paid pursuant to the demand of the railway authorities on the ground of such punitive charge within 1 week from the date by demand drafts for the amount paid by the petitioner in each of the writ petitions. That apart, the respondent number 3, 4, 5, and 6 in each of the writ petitions who are principally responsible for illegal and unlawful punitive charges being imposed shall each pay cost from their own pockets to the petitioners in each of the writ petitions at the rate of ₹20,000 each in connection with each of the writ petitions by April 30, 2022. In the event such costs are not paid to the writ petitioners in each of the writ petitions within the time stipulated herein, the petitioners in each of the writ petitions shall be entitled to move the court for deliberate contempt of court on the part of the defaulting respondents. The parties and all concerned shall act on the written communication of the learned advocates of the petitioners in each of the writ petition, accompanied by server copies of this order, without insisting upon prior production of certified copies for the purpose of compliance. The purported certificate of verification issued by the Office of the Controller Legal Metrology dated September 14, 2021, which is handed over in court today and discloses precious nothing, be kept on record. In view of the disposal of the matter, further personal appearance of the Senior Divisional Mechanical Engineer, Southeastern Railway, is dispensed with. My lord, this was the order. Now, this order was taken, this was challenged before the Honorable Division Bench. My lord. Next page. Honorable Division Bench affirmed the order of the Honorable Court. Honorable Single Bench. My lord, which the next page, my lord has found.
These judgments were referred to earlier.
This was earlier referred also. Only thing we have to demonstrate before your lordship that the in-motion weighbridge was not functioning properly, and the tear weight, the empty weight, which is appearing from the joint report, has a stark contrast with what is actually leveled in the wagon itself. In the wagon, it is usually 32 tons, but in the Vement, it is appearing as 30.70. That too after application preferred by the railways seeking a repair upon the legal metrology, my lord. This has to be taken into account. Also, the division bench judgment is there. So whatever punitive charges which I have paid to the railways under protest and the allegations which I have made against the railways stands vindicated, my lord. The punitive amount should be refunded back to us. This is my submission, respectful submission before this honorable court. I have handed over the judgments.
Yes. Let us continue on the next day. Will you, in the meantime, inform, because the legal metrology should be represented?
That he should be represented.
Yes.
Because until unless legal metrology should apprise the court regarding the wrongdoings of the railways. Because legal metrology.
In fact, several communications between the railways and the legal metrology.
Yes, my lord. Only the thing is this. When the matter initially was filed before this honorable court, the certificate of legal metrology was highlighted, showing that it was weighing correctly, my lord. Now, thereafter, when the order was asked to be complied, they found that the in motion weighbridge is defective. And thereafter, the blame game started between the railways and the legal metrology. Railway initiated an application seeking a direction.
Was anyone representing the legal methodology earlier?
Legal metrology, probably, my lord. Legal metrology, probably no one was.
Sent no one.
In that case, if your lordship so desires,
I do not find anyone in court now. Actually, will you
I
inform
think
Mr.
Mr.
Sen?
Sen Junior is, apni achen ei matter. In that case, my lord will ask me to serve a copy upon metrology. I come back.
Do that. On the next day, I'll regularize his appointment.
I regularize.
Let us continue on the next.
There is no such allegation that the motion weighbridge was not functioning properly in the writ petition. Allegation was this, that the weight of the particular wagon was not correct. For this reason, they prayed for a direction for weighment of that empty wagon. And that was done. And my lord, what was the result? That was found, that is the 30 tons.
He has not completed. I think let him come back. And let the legal methodology be present at least.
Only
My
that
lord,
is
what is stated in the writ petition and what is argued today is completely different.
We'll see. We'll go
because of the reason, lordship, various letters which were exchanged between the railways and the legal metrologies. And also one thing, lordship, is a basic fundamental thing. The weight of the empty wagon has to be on a in-motion weighbridge. It cannot be scaled in a weighing scale. Just like we measure vegetables, it cannot be done like that. It has to be on an in-motion weighbridge. If the in-motion weighbridge is defective and malfunctioning, the responsibility has to be borne and shouldered by the railways, because they themselves highlighted. Rather, I will use this word, my lord. They have tried to mislead this honorable court by showing a certificate which in nature is not true.
Prayer C deals with the in-motion weighbridge. Prayer C of the writ petition.
And
Rectifying the motion weighbridge. And my lord, there is no such report from the legal metrology. They are the actually responsible regarding the weights and measurement.
That's
which
why
are
in course
existed.
of hearing your argument, I
My
felt
lord,
that the
when-
legal methodology should be present.
Yes, then in that case, my lord, lordship, direct me to effect a service, because I think I have effected a service. If probably further service is required, probably this case dates back to 2019.
They have their own stated that the weight of that, my lord, the 17,600, and actually it was found, my lord, 25,100 kg. So for this reason, my lord, penalty was charged for that overweight.
Legal metrology has
ultimately,
been
my lord,
actually served.
Actually
Just,
served.
no one is appearing. So just intimate the date
Intimates.
and please
Lordship, in
inform-
that case, my lord,
better if you inform Mr. Sen.
Mr. Sen.
He generally appears for the legal metrology.
Lordship, he is the junior to Mr. Sen,
Will
lordship.
you please take note of this matter so that Mr. Sen can appear on the next date?
Yeah, yeah. Lordship, so desire I will serve a copy of the paper book.
Please do that in advance. so
Lordship,
that we
fix
can
a
deal with
date.
the matter.
Tomorrow I am
I will.
doing.
Her learned counsel for the petitioner. Paragraph, let the matter appear under the same heading on June, next week. A
Oh, yeah, I'm
paragraph,
effective, sir.
since the legal metrology is not represented, paragraph correct, the petitioner is directed to serve notice upon respondent number. Is respondent number?
Legal methodology.
7. What legal metrology na kore, since the 7th respondent is not represented, the petitioner is directed to serve notice upon the 7th respondent, intimating the adjourned date. Please apprise Mr. Sen.
Yes. Great.
You have almost completed. your
Almost
submission.
completed, my lord. In the event, I will for the.
I do not know why affidavits are called for. We could have dealt with it at the motion stage itself.
Yes, yes.
Similar matters have already been dealt with. Anyway, come back.
Great.